Yes.
Judgment Hassan.
For the announcement of judgment, RSA 112
Appeal is dismissed. This is sent to, no? Yes, Mr. Das.
Well, may I mention, I was not to have, of course, but it appears, well, it is top of the list. May I mention, well, these two items to do it on Tuesday night,
On
or Thursday night.
Thursday.
Thursday.
Next Thursday.
Next Thursday.
Next Thursday before the vacation.
Before the vacation, or well, or if not possible, then Tuesday, well,
We can try on Tuesday. Let us not go to
Yes.
Thursday. Tuesday.
I have one Tata
Huh?
matter, report number
Now
one.
we'll accommodate you. These are old matters.
My lord, yes, I'm ready otherwise.
Okay. Mr.
but I
Das,
can say, well, he will not be here.
who?
Well,
Tuesday I have typically.
We are accommodating a senior counsel, not you.
I have to assist, sir.
Not you. You make some arrangements. 14 matter. Otherwise, you would have no
I am-
problem.
I
You are for the appellants.
I
Mr.
will
Das?
accept.
Uh,
Item number 2.
Two and
Okay.
division.
A request has been made by Sri B.C. Das, learned senior counsel for adjournment. Full stop. Also heard Sri G.N. Sahawala, learned counsel for the rival party. Full stop para. Considering that these matters are of the years 2013 and 2014, a short accommodation is granted. Directing listing of this matter on Tuesday next. 22. Yes.
May I mention item number 15 and 16 matter.
On Mr. Das on Tuesday.
Yes.
Okay.
sir.
Huh?
How was it? How was-
25. Tuesday, 25. Yes.
15 and
Ah.
16 matter.
Yes.
I say, my lord, these two matters may come after vacation, my lord. In fact, my lord, I could.
Matter of which year? Matters of which year?
22. 2020.
Who is for the other side?
Other side, I have taken consent, my lord, Mr. P. Jalal.
Yes,
Please,
Okay, 15 and 16. Yes, when?
after vacation, my lord.
Okay. Madam, after the vacation? On a request made on behalf, made by Sri G.N. Sahal, learned senior counsel for the petitioners. Matters are adjourned to be listed after the summer vacations. Yes.
Right.
Any interim protection?
Already there.
May I please, kindly call for a written argument in item number 21, your lord, who is submitted before the honorable court. Written argument who is submitted in item number 21.
Yes. What do you want?
Kindly call for a written argument.
Written argument, you are not supposed to file, you can give it place in the court.
Sir, sir.
Where are your arguments?
In item number 21. sir.
No, where is it? It's with you.
Yes, with me. And
Present-
I know, I have already filed before the,
It's not required to be filed. You can just. Why written argument is required?
because we have to place some facts, your lordship, wherein the net salary has been deducted by deducting the provident fund, which has been against the Sarla Verma's case, your lordship. That is why we have to place before the honorable court for enhancement of the compensation, your lordship.
Item 21.
21, supplementary list, your lordship.
21 is an appeal by the insurance company.
Insurance company, we are the claimants, wherein the claim amount has been deducted, your lordship. We have placed some the facts, your lordship, to wherein the claim amount has been increased, your lordship, maybe increased.
No, where is your cross appeal?
The cross appeal, your lordship, by this honorable court coordinated bench has been negating that cross appeal had not been required. And it is, I have also annexed that judgment, Your Lordship, of this honorable court, wherein this honorable court in taking up decision has been taken that cross appeal has been not been required, Your Lordship.
No, if there was no appeal, if there was no appeal by the insurance, would there have been an occasion to consider your enhancement?
Though, Your Lordship, the calculation which has been made by the Learned Court below, Your Lordship, tribunal, Your Lordship, ought to have been, some mistakes has been committed, Your Lordship.
No,
regarding-
where is your appeal? You are not aggrieved.
Your Lordship.
Neither there is an appeal, nor there is a cross objection.
May I please, Your Lordship, I will place the argument, Your Lordship, at the time
You
of.
will be in difficulty.
Lordship.
You will be in difficulty,
Though, Your Lordship,
at least on the part of enhancement. Without an appeal or cross objection, these are matters of civil nature. Will not exercise equity jurisdiction.
though, Lordship, this honorable court I will place the judgment, Your Lordship, wherein this clause has stated, despite the cross appeal has been not been placed.
See, if
The-
there is a cross appeal and you have not taken a specific point, we may incorporate that point. In absence of an appeal altogether,
No.
where is the scope?
No.
Tell us.
I will,
I think you think over, you can file a cross objection even now, delay condemnation, we can condone delay, but we have to maintain the formalities.
Lord,
Without the maintenance of formalities, we cannot just. There has to be some form of an appeal from you.
Lordship.
Let it come, we'll decide, we may give you some time,
Lord,
okay?
Lord.
Or you can try some other bench.
No, that is not, Lord.
No, we are telling very frankly.
No, Lord.
So far as the insurance company's appeal is concerned, we do not know, we may dismiss it even. But if the question of enhancement come, let it be all on your behest. And if there is no cross appeal or a separate appeal, we'll not consider it.
Lord.
Sorry. Yes, madam.
Why not, the it is titled to 6 and 7.
Hmm.
Seek accommodation method by the place that is appearing at the 6. That means, 7 might not be for the evidence.
These are old matters,
Lordship,
madam.
I object, Lordship. The Lordship will produce the orders.
Court need not object. There is an objection.
Objection, I object, Lordship, very lengthy. Last occasion, Lordship, there has, and the court.
Okay, let it reach.
Yes.
Let it reach.
That is read by senior counsel. And on it, that is
Okay, let it reach. We'll pass orders when it reaches.
obliged.
We may not take up the matter, but at least there is an objection. We'll try to hear the
Alright.
objection. Yes.
May I, Lordship? Lordship, back to item number 5.
5, Mr. Das, what is 5? Yes.
Lordship, my senior is a personal difficulty compared to
Who is your senior?
my Dilip Mazumdar, Lordship.
Why do you need a senior? You're an able counsel. You argue so well.
I am
Lordship,
appealing
my
for the respondent.
family
Mr.
member,
Das, what do you say?
Lordship, my family member.
Your lordship knows it well.
That is why we are saying.
Senior counsel engaged from my family member.
But I have prepared it, I have come for it. Only.
See, even the other,
That's why I took the adjournment into, I don't know what.
see, even senior counsel is ready.
I understand.
You have
My-
a chance.
No, Lordship.
Scope, don't lose the scope.
Lordship, as per the instruction, my senior Lordship. Please after vacation, Lordship.
19 matter, not after the vacation.
After vacation, near the day, Lordship.
What is the matter about?
Lordship, matter regarding Lordship, the partition matter, Lordship, in between the two daughter and two mother.
Whether it is a final decree proceeding. And they have come in the big state. Why?
Decree has been passed.
No,
Is decree passed?
preliminary decree was passed.
A preliminary decree has passed. They have challenged the preliminary decree.
No, that they had challenged it and they got it. Now the decree is for final decree preparation.
Okay,
We have filed an application
okay.
under order 20, rule 18 for final decree preparation. And in the midst of final decree preparation, they have advanced it.
No, revision is against what?
Revision against the order of the court below, sending the matter back to the authorities concerned.
For preparation of the.
for-
How are you aggrieved?
Lordship, one thing is the Lordship, the matter is very simple.
We thought this was an
No,
appeal
Lordship,
against the final decree.
Lordship,
No, no,
Lordship, the put into operation, the preliminary decree which is finalized by the second appeal. They have, I have challenged, they have challenged the cancellation of the sale deed, Lordship. I am the legal head of the performance defense on 15th, Lordship. So they did not. take
Okay,
into
yes,
case, Lordship.
we'll have a date. He is having some difficulty.
but it is in August, whether it July, I may get extended vacation.
We'll fix it towards the end of the month of July, on 30th of July,
Yes, Lord.
30, that's a Tuesday,
Wait.
30. Long after July, last part of July,
Yes, yes,
30th.
that can be done.
A prayer for adjournment has been made on behalf.
So 30th, can it be 31?
31st to be Wednesday again.
Oh.
We'll try on Thursday, with Tuesday, 30th, 30. A prayer for adjournment has been made by Sri R.C. Das, Learned Counsel for the petitioner. Para. Also heard Sri B.C. Das, Learned Senior Counsel for the respondent numbers 1 and 2. First of para. Considering that the revision is pending since long, do adjournment is granted, let it be listed for hearing again. For hearing on 37.
Lordship, interim order.
Oh, your
Yes.
interim protection.
Yes, sir. Yes, sir.
Interim order stands extended till the next date of listing.
Master.
May I please? My lord, I think to mention item number 14, my lord, with the consent of the other side.
1-4.
1 for my. Let it be after vacation. 1 4. I've taken the consent from Mr. K. Gogoi.
Your tea sake.
Yes, my lord.
On the prayer of Sri T. Sake, Learned Counsel for the appellants. Matter is adjourned to be listed after the summer vacation.
Highly obliged.
Sake
Lordship,
to pura likhibo, SK nahi likhibo. Sake pura likhibo.
Lordship, I beg to mention item 12, Lordship.
Yes.
With the consent of the other side, Lordship, I'm praying on behalf of Mr. A.B. De, Lordship. Lordship, matter may be passed for a day, Lordship.
Okay, when do you want? Next week, it may not be possible. It'll go immediately after the vacation. Okay?
Yes, sir.
On a same, huh? On your Sutradhar.
Yes.
On a request made on behalf of Sri A.B. De, Learned Counsel for the respondent number 1, matter is adjourned to be listed immediately after the vacation.
Obliged.
Okay.
Your lordship, this matter may kindly be passed over for the time being, lordship. Mr. Pritidatta is coming, lordship.
Okay. Mr. Laskar, time being.
Well.
Much obliged.
Obliged.
Item 19 and 20, submits.
मेरा पाठा रहे ना है अच्छा अच्छा एडमिशन से ओके 1920 Mr. Goswami, where is Mr. Goswami, regular member? Mr. Goswami, here be the I think. Yes, any representation by Mr. Goswami? None appears for the appellant stroke petitioner. In this case, where is Mr. Kyle? Kyle is also not there. There is no representation of the respondent also in the CRP. Full stop para. In the interest of justice, matter is adjourned to be listed immediately after the summer vacation. Same party है ऐटा order दिबा FAO CRP एक लगे दी. Yes, next.
Item 4, are heard.
May I please, your lordship? My lord, I have to take your lordship the earlier, the second appeal order passed by the Honorable Court on 6/8/18, my lord. Only two paragraphs I like to draw your lordship and attention. First.
To which page?
My lord,
Page
page 42, para 7 and 10.
Kindly for 5 minutes, you can just refresh.
Yes, my lord. In this case, what happened, my lord? So it is a trial court, my lord, concurrence against concurrence findings, my lord. Then it is a present appellant approach before this honorable court.
Just a minute, just a minute. Suit was for declaration of khas position.
First position, my lord.
Okay. And
Uh,
you did not exhibit any document.
that is true, my lord.
Okay.
That is true.
The defendant had admitted that you are the owner.
That is true, my lord.
Okay,
Yes, my lord. And
but
the most important part, my lord, in this case, and though, my lord,
just a minute. Plaintiff are the owners of A scheduled land,
yes, my lord.
and defendant claimed that they were tenants
In end of BC the land.
of B scheduled land.
Yes.
And B, according to you, B is a part of A.
According to me, B is the part of A.
Schedule A Khatian is 283,
Yes, my lord.
Dag number 361.
Yes, my lord.
And Schedule B, you say is the
Khatian number
area,
315. Right, Khatian number 315 and that number 3229 old and 2500 new.
no, the B scheduled land is 30 by 50.
Yes,
It's a, you, according to you, it's a part of A scheduled land.
as to the land below.
Okay, A is the bigger plot, inside it is the B, which is the subject matter of the suit land. You are seeking for a declaration for khas possession,
First project.
okay?
And here in this case, my lord, the appellate court, my lord, direct court, my lord, with the same three issues. And it is stated here, declared the petitioner is the owner of the asset land. And also issue number 2, that defendant is the evictability land, evictable. It's already declared. But subsequently, Mr. Party, when decided the issue number 3, absolutely the contradictory stand held that issue, even already held, even my lord, more interestingly, this is the here in this case here, my lord, we already approached before this call earlier round, my lord. And this honorable court paragraph 7 and 10.
Page
42.
4-2.
Yes, my lord. That's what. Page 42, my lord.
Yes.
Paragraph, paragraph 7. At the outset, the learned counsel for the appellant has invited the attention of this court to the pleadings in the plaint as well as the written statement, which goes to show that the BC land claimed by the plaintiff is covered by Khatian number 283 of Act number 361 of village Mankasar Part 1 under Mankasar Circuit, whereas the respondent defendant has claimed tenancy right over the land based on right Khatian number 315 involving Act number 3229 old and 2500 new. As such, there is an apparent discrepancy in the description of the suit land as well as land claimed by the defendant.
Yes.
Already this honorable court held that there is an apparent discrepancy, the description of suit land as well land claim. But now, Lordship, kindly have a look at paragraph finding, paragraph 10, page 43.
Page 43.
43. Though plain pretended statement, all this material available, it is true. There no exhibit exhibited by the plaintiff. It is all there. And in written statement, they have stated that their land is different variety Khatian number. And my plaint also I've stated my different. Now, paragraph 10 is the observation. I have considered the submission advanced by the learned counsel for the parties and have also gone through the materials available on record. As noted above, the key controversy involved in this proceeding relates to the right of the plaintiff in respect of B scheduled land, which claim was declined by the learned trial court on the ground that the said plot of land was under possession of the respondent, who is the non-evictable tenant. However, there is no finding recorded by the court below as to whether a defendant is in possession of the Schedule B land. The discrepancy in the identity of the land as projected through the pleadings of the parties, prima facie goes to show that both the lands are not the same plot of land, or alternatively, at least the description projected through the pleadings are not correct. I am therefore of the view that the learned court below was not correct in dismissing the plaintiff's suit without ascertaining the state aspect of the matter. Although Mr. Majumdar has submitted that there are materials available on record to establish the claim of the defendant, yet I am of the view that in exercise of the power under Section 100 CPC, a second appellate court would not embark upon task of the recording any findings of facts for the first time. In such view of the matter, this court is left with no other alternative but to set aside the impugned decree dated for 24/12/2003 and remand the matter to the Lower Appellate Court for a fresh decision of the title act. Here, already paragraph 7 and paragraph 10, it is declared, yes, the prima facie established there is a discrepancy in the identity of the land, and Learned Appellate Court, without no need to go to other facts, only to identify whether land claimed by the plaintiff and land claimed by the defendant is the same land or different land. It is to be asserted. What Learned Appellate Court has done. Now, this is the question involved here, my lord. Now, Lordship, kindly have a look on title appellate impugned judgment, my lord. I'd like to directly take your lordship, my lord.
Page
Page 29, my lord.
29.
Yes, my lord.
Yes.
In paragraph 29, my lord, the appellate court has, the trial court has framed three issues, my lord.
This is the
Yes.
order after remand.
Yes. My lord,
Oh.
the trial court has, this is earlier trial court has framed this issue.
No, this is the
Yes, after
29,
remand.
24 June.
Yes, my lord. This is after remand. 24 June 2019.
This is by the first appellate court
Yes, my lord.
on remand.
On remand.
Yes. You are at 29.
Yes, my lord. Page 29.
Yes.
Serial number 10, my lord.
Hmm.
The Learned Trial Court has framed the following issues.
Yes.
Whether defendant acquired rarity status under plaintiff in respect of the suit. Number 2, whether defendant is evictable, whether the plaintiff is entitled to get any. This is trial court's issue framed according to appellate court record. Now, my lord, additional issues. Is this suit not properly valued? Number point for determination. What the point of determination? 1. Whether plaintiff's appellant had been able to prove that they are the owner of the air civil land. B. 2. Whether the plaintiff appellant had been able to prove that this civil land is the part of the air civil land. Number 3. Whether the suit
Yes,
land.
we have read.
Yes,
Okay.
yes, yes. Now, my lord, ultimately, my lord, the appellate findings, my lord. Page 31, paragraph 16.
Yes.
Where this honorable court specifically directed that to ascertain that issue, though appellate court is entered and this issue discussed, my lord. It is clear from the evidence of the defendant that he came to India from Bangladesh and was allowed to stay in the plaintiff's house temporarily. So the defendant originally hailed from Bangladesh. The defendant has not said clearly in which year he came to India from Bangladesh. The defendant's side had not examined any official from Revenue Settlement Office to prove the fact that any resettlement of the Mankachar town area was conducted in 1991 and the Rayati Khatian was in fact been issued in his name. When the defendant has said that he has come from Bangladesh, it has become more important to see in which year he has come to India and whether he has obtained Indian citizenship or not before claiming any right over the lands of Assam or elsewhere in India. Because the land rights are available only to the Indian citizens, the defendant claims that he was first allowed to stay temporarily and subsequently he was settled as tenant by the plaintiff. Admittedly, there is no written agreement between the plaintiff and the defendant. Hence, the strict proof is required. The land record, landholding certificate does not mean that the person is entitled rightfully having the state land. The landholding certificate and the revenue receipt simply imply possession, but one has to justify his possession. It is not sufficient if somebody has got Rayati Khatian, that means he has rightfully got the same. He has to show that he has rightfully got the Rayati Khatian and the documents are not manufactured. In this case, there is no written agreement of the tenancy between the plaintiff and the defendant. Secondly, the defendant has come from Bangladesh and he has not shown in the which year he came from Bangladesh. He also not shown that he has got Indian citizenship. the defendant has not proved his inclusion in the Kachapatta as riot in the Iri settlement 1991 by examining any settlement official. For above reason, I find that defendant respondent had not been able to prove that he was a tenant under the plaintiff. Issue number 1 is decided in the negative in favor of the plaintiff and against the defendant. As I find that defendant has failed to prove that he is a tenant under the plaintiff's appellant, I find the defendant is evictable. The issue number 2 is decided in the alternative affirmative.
Affirmative.
In favor of the plaintiffs against it. That means, my lord, by the issue number 1, that schedule 1, it's against the defendant, and issue number 2 also, my lord, is the evictable already declared, my lord. Though, my lord, though it is the evictable tenant already declared, it is but this issue already findings against the defendant, my lord, same has not been the challenge by the defendant. Now I am not on the my argument is on from paragraph 17 onwards, my lord. Now, for the first time, the appellate, after remanded, this appellate court is taken. The direction, what direction made by the Honorable Court, discussed from paragraph 17, 18, and 19 below. First, paragraph 17 below.
Yes.
Yes. Para 70, page 32, my lord. The Honorable Guwahati High Court wrote in paragraph 10 of the judgment of RSA number so and so. My lord, already paragraph 10 I have read, my lord.
Yes.
No, my lord, paragraph 7 ought to have been recorded here, my lord, but only 17. Next, my lord, the discussion with paragraph now, it is to be decided, my lord, whether paragraph 18 and 19 discussion is by the appellate court, my lord, whether as per the direction made by the Honorable Court or not. This is the question involved here. The plaintiffs have sought declaration that they have got right title and interest over the B civil land and for first possession of B civil land. According to plaintiffs, the civil B is the part of A civil land. The A civil comprises of land measuring 1 bigger 3 cutter 19 letters, covered by Khatian number 283, dark number 361 of village Mankachar, part 1, circle Mankachar. The defendant has claimed that he has got right Khatian 315, dark number 20 under the plaintiff for 1 cutter 19 letters. Land and B civil land is the part of the land. Neither party has disputed the identity of the suit land either before the trial court or before the first appellate court. That means, you know, they both parties admitted the lands are different, the duck number, 13 numbers are different, but both sides has admitted it. Rather, in paragraph 8 of the WS, the defendant has written that as per the land records, plaintiffs have got 4111 letters situated in village Mankachar, part 1, covered by Khatian number 283 and A civil land, the part of the state Khatian, and defendant is a tenant of the land 1 kata 19 letters out of the A civil land measuring 22 letters, and defendant has got right Khatian under the plaintiff's land. My lord, only relying on the paragraph 8 of written statement, this is the observation made appellate court. Now, again, my lord, so it is clear from the WS of the defendant, the right Khatian number 315 and that number is going to belong to the Khatian number 8. Plaintiff A civil land. So I find that suit land and the land over which the defendant respondent has obtained the right Khatian is the same land without complying High Court's decision, my lord. My lord, this material was also available before the second appellate court. May I rely reading the stating what is written in the statement? This is the finding made in paragraph 13 below. This material is also available before the Honorable Court. Therefore, this Honorable Court is finding this is not sufficient. You are certain whether land described in the court land either same land or different land, my lord. But here in the observation made, only relying the whatever statement when in written statement only. Now paragraph 19 below. The plaintiffs claim that they are the owner of the A civil land and the B civil is the part of A civil land. The plaintiff side had not exhibited any document regarding their ownership land over the A civil land. The admission of the defendant that the plaintiffs are the owner of the land over the which he has obtained tenancy Khatian does not itself make the plaintiff owner of the A civil land. And I'm sorry, my lord. Here, my lord, it is the actually contradictory stand, my lord. Already issue number 1 and 2 decided in favor of the plaintiff. Now, the plaintiff must have produced the exhibited documents showing that they are in fact the owner of the civil L. And this is the question, not the question. Yes, it is absolutely true. The plaintiff has not exhibited any documents, my lord. It is true. And this materials also were available at the time of second appellate to before the Honorable Court, my lord. This is not the issue here, my lord. Only appellate court is only remanded the only on ground that we ascertain the land claims by the plaintiff and land claimed by the defendant is the same or different land? This is the only question involved here, my lord. Had there been any revenue records before this court showing ownership of the plaintiff over the asset of the land, this court would not compare that whether the land over which the defendant claims to have obtained the right to khatian is same as the civil land or not. The plaintiffs have shown declaration of right title and interest over the civil land which they claim to be a part of civil land. Hence, the plaintiffs have to prove first that they are the owner of the civil land, my lord. Whereas, my lord, only to ascertain if the land, but here the question is.
Just a minute, please. The suit was for a khas position or what?
Khas position.
But in the relief prayed, you had also prayed for declaration.
Right title interest, first prayer, second is the khas position. On civil land. Whether the civil land is the part of civil land, this is the only question involved. And therefore, this appellate court, second appellate court is tribunal court is demanded to ascertain first that the land claimed by the defendants, the land the claimed by the plaintiff that he was dispossessed from the civil land is the same land or different land. Sorry.
Okay.
Hello. May I continue again, my lord?
Yes, yes, please.
Hence, the from fourth line, my lord.
Yes.
Page 34. Hence, the plaintiffs have to prove first that they are the owner of civil land. This is not a question, but for the reasonable demanded. There is no documents from the plaintiff side in support of their claim. The plaintiff will not automatically become owner just because the defendant has said that the plaintiffs are the owner of the land over which he defendant has got the natural right. I find that plaintiffs have failed to prove that they are the owner of civil land. My lord, it's absolutely contradictory. Already in paragraph 16 of judgment of Lord just has gone to my lord that he has declared my ownership, lord. As such, I find that the plaintiffs are not entitled to any relief. So issue number 3 is decided in negative in favor of the defendant and against the plaintiff. I find that the plaintiff's appellant had not been able to prove that they are the owner of the civil land and civil land is the part of the civil land. My humble submission before this court, in my lord, paragraph 20 is not, my lord, only the paragraph 18 and 19, I am posing my argument, my lord. Here, my lord, this honorable court is only simple direction made. Since both sides in paragraph as per the paragraph 7 and 10 of the this honorable court judgment, my lord, there is certain prima facie found a certain discrepancy in the land claimed by both the parties. So appellate court direction, instead of going to the other facts, my lord, is not asserting this fact. Here in this case, absolutely the appellate court is not done as per the direction made by this honorable court, my lord. Here, my lord, the learned trial court, my lord, appellate court, my lord, ought to have been, my lord, after remand and back, my lord, the other 26 rule 9, there is the power. The order 9, the 26 rule 9, kindly have a look, my lord, TPC, my lord, order 26 rule 9. Under such circumstances, both the parties claiming differently. Under such circumstances, only the whatever written in the defendant's statement is that it is proved. Why? This matter also available for this court. Now, my lord. May I read, my lord? 9. Commissions to make local investigation. in any suit
Please,
in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute, here, my lord, any dispute, or of ascertaining the market value of any property, this is not involved, my lord, or the amount of any means profits on this damage or annual net profits, the court may issue a commission to such a person as it thinks fit, directing him to make such investigation and to report thereon to the court, provided that where the state government has made rules as to the persons to whom such commission shall be issued, the court shall be bound by such rules. Now, here in this case, my lord, instead of comparing the return, whatever is written in the written statement, only relying the statement made in the written statement has passed delivered the impugn judgment, my lord. In support of my case, my lord, one judgment, my lord, I'd like to place your lordship, my lord, in the Himachal Pradesh High Court has decided on similar circumstances, or lordship, I like. Oh, sure. That except paragraph 30, 15, 17. Lord. Yeah, my lord, order 26, rule 9 discussed elaborately.
paragraph,
Paragraph 13, 14, 15, and 17. Sorry, my lord.
paragraph
13, my
13.
lord. May I read, sir? Rule 9 of Order 26 of the Code of Civil Procedure empowers the court to issue commissions to make local investigation which may be required for the purpose of elucidating any matter in dispute, though the object of the local investigation is not to collect evidence which can be taken in the court, but the purpose is to obtain such evidence which from its peculiar nature can only be had on the spot with a view to elucidate any point which is left doubtful on the evidence produced before the court. To issue a commission under Rule 9 of the Code 26 of the Code, it is not necessary that either or both the parties must apply for issue of commission. The court can issue local commission suo motu if, in the facts and circumstances of the case, it is deemed necessary that a local investigation is required and is proper for the purpose of elucidating any matter in dispute, though exercise of these powers is discretionary with the court. But in the case in the local investigation is requisite the court and proper in the fact and circumstances of the case, it should be exercised so that a final and just decision is rendered in the case. In Braham Datta versus Premchand versus so this court held in paragraph 14. B, it stated that whatever was within the power of the plaintiff to show that a piece of land owned by him has been encroached upon by the defendant has been done by him. If the revenue agency has prepared a report which cannot be according to rules, the case of the plaintiff could not have been thrown out simply for the lapses committed by the revenue agency or tahsildar in carrying out the demarcation. No amount of oral evidence which could be held by the plaintiff would have established the identity of the encroached land. To identify it, the only way was to get it demarcated. The plaintiff adopted that approach and nothing more could have been done by him. In case the appellate court entertained any doubt about the correctness of the demarcation and the report, the prayer of the plaintiff for the appointment of local commission for demarcation of the suit land to find out the extent of the encroachment, if any, ought to have been exceeded. It is the duty of the court to ensure that substantial justice is delivered to the parties, and that for the mistake of any government agency in demarcating the land, a party should not be deprived of the justice on merits of by taking recourse to the technicalities. Para 15 below. Once the learned district court has entertained doubt about the correctness of the demarcation given by the tahsildar, he ought to have appointed a local commission to demarcate the disputed area to find out whether there was any encroachment, or if so, to what extent. Instead of proceeding to dismiss the suit, the impugned judgment and decree therefore cannot be sustained. In the case in hand, the already stated the preparation of the correctly was not within the powers of the parties, and they did whatever was possible on their part. Therefore, after coming to the conclusion that a part of the suit land is in possession of the plaintiff and the defendant is interfering with his possession, it is necessary for fair and just decision of the case to ascertain the actual position of the spot, which can be best ascertained by issue of commission at the cost of parties, para 17, my lord. In the given circumstances, the only course left open to this court is to remand the case to the lower appellate court with the direction to appoint a local commissioner to carry out a local investigation and therefore dispose of the appeal in accordance with law. My humble submission in this case, my lord, though, my lord, the earlier round, my lord, this honorable court by giving a specific direction remanded back and you decide only on this point. But here, my lord, the appellate court though decided issue that I am the owner of the asset land, also of defendant is an evictable tenant. But therefore, by very contradictory statement made, though, my lord, when the question of remand, this honorable court direction, this concern, instead of applying these provisions of law, my lord, he has only decided on the basis of whatever written in the written statement. That evidence also available before this honorable court at the appellate stage. My humble submission in this case, though it's a very old case, my lord. So this is, my lord, the interfering the appellate court judgment, my lord, this matter ought to have been remanded back and directed the applying these provisions of law and for commission and to ascertain the final letter actually who are in actual in question. And this is my respectful submission. Obliged.
Yes.
May I please go to- Quickly, this judgment is after the remand. And the order 41, rule 23, the appellate court power is said, appellate court has demanded the order 41. And for what? It is at page 43. Page 43, Lord.
Yes.
Paragraph 10, last line. In such view of the matter, the court is left with no other alternative but to set aside the impugned order that is so and so, and remand the matter to the lower appellate court for a fresh decision of the title. This is the remand order. Because order 41 will rule 23 and subsequent to that, if the court picks a issue that you decide this after remand, then it's a different matter. That you go for a commission, local commission and whatever, then you decide. These things are not there in the second appeal judge. Second appeal said, go for a fresh decision. Now, if the court has to go for a fresh decision, let us see, because we have to, in a decision of the case, we have to see what is the plain path. What is the suit for? It is at page 6.
Yes, we have noted.
That loss.
We have noted. That is why we have asked this question. Though initially the first part says khas position, in the relief prayed, it is also for a declaration of right title interest.
Yes.
We have noted that.
It is a suit for declaration of khas position value. That. So it is, if it is a suit for declaration khas value, it is 100 lordship. If it is a suit for declaration of the land, then it has to be the value separately. It is not separate value. No valuation. It is a khas position valuation 100 on. So all these things are there.
No, how does this submission will help you? He is only praying for a declaration of khas position.
Yes.
Even if we ignore the first relief, the declaration of right title interest,
Yes.
if that even that is not an issue to be, or that issue is not decided or has not arisen for decision.
Yes.
What is arisen for decision is the
Khas position.
khas position
Yeah.
for which court fee has been paid. And that has to be decided.
That has to be decided.
Yes.
Then lordship, for a khas position, it is the duty that you have to decide you have to prove his case. It is the plaintiff's duty to prove his case that he has title. To get the khas position, you have to prove his title first. He has not given a single document with the suit. Not been exhibited.
Now, in all suits, is it required that you have to have a
Yes, otherwise,
absolute title
otherwise
for
Lordship,
cast
they have
position?
the policy should always. Tomorrow I'll file a suit against Mr. Bhuyan.
No,
In a collision.
there can be many instances where even a person not having a perfect title he can also pray for recovery of caste position.
Recovery of caste position.
Declaration of title is a
All
different
right,
matter
all
altogether.
right. Then if the defendant has said that I have the Khatyan and all that, then you have not amended your claim then and you have not come for any relief on that. You have not amended your claim to that because that was not challenged. Rightly, wrongly, the Khatyan was proved without objection. And there is no prayer against the Khatyan. So a plaintiff will not get the caste position when the defendant said, I am a Khatyan.
You said that your Khatyan was not put to challenge.
No. No. That is why Lordship, even Lordship, with all respect, Lordship, normally I not do this, but the judgment was set aside, so I have not to read that judgment. But I think, Lordship, the best judgment is the earlier appellate court judgment. Legally, lawfully, it was decided, though it is set aside. If Lordship,
No, once it is set aside, we'll not go back to
no,
the.
Lordship, I know, I know.
And set aside by
But
this
Lordship, in
court.
the record,
Yes.
in the record, this judgment is there. My argument,
No, you can formulate your argument taking assistance of what are the materials there, but we cannot just go into a judgment.
Lordship have not to see the earlier judgment, but what the earlier judgment has said, it is in the record, Lordship, earlier judgment, and it is very clearly said that it appears from the evidence on record that the exhibit core, which is a Rayati Khatyan, in favor of the defendant, was exhibited without any objection. The plaintiff appearance did not make a whisper as to the Rayati Khatyan, which was issued in the year 1991 in favor of the defendant respondent. The plaintiff appellant did not take any steps for cancellation of the Rayati Khatyan. Exhibit core, if the Rayati Khatyan is wrong or the fraudulently obtained, it must be required to cancel within the prescribed period of limitation, that is within the year 1993 to 1994, because
54.
that is 54. Or at least in the suit at the hand, after the knowledge about the Rayati Khatyan. But nothing has been done, as the Rayati Khatyan has not been cancelled, it still remains valid. Considering this aspect, the learned trial court rightly held that the defendant is a riot under the plaintiff with respect to the suit plan and rightly decided the issue number 1 against the plaintiff. I find no reason to interfere in the finding of the learned trial court as required issue number 1. So that is precisely my point. Lordship, the plaintiff has not.
Mr. Sharma, one thing is troubling us. The judgment, which is now the subject matter of challenge in this appeal,
Yes,
which
There
has
are
been,
seven,
which has
Lordship.
been preferred by the plaintiff.
yes,
Now that judgment has come to a finding that you are an evictable tenant.
yes.
And that part has not
He
been,
is evictable tenant, Lordship, right? Evictable tenant, Lordship, there is no doubt. But the evictable tenant procedure is there.
no, if you acquire the status of a non-evictable tenant under the 71 Act, that your status becomes different. You have not obtained that status as per the first appellate court judgment after remand.
Right.
And that finding is not put to challenge by you.
No, I am not, because the suit is dismissed. Ultimately, he has not given the relief. He said that you are not correct.
No,
Your-
relief has been denied on a different issue. But the
No,
issue,
no, Lordship, if the suit is dismissed, ultimately, finally, what the court done? Court said the suit is dismissed.
but that finding remains.
With that finding, let him go and file a fresh suit. What prevented him? Why I will go for, because when the suit is dismissed, what is, why I will go for a appeal? It is a finding only. Finally, the suit is dismissed and said you have no claim, you have no right, You have not proved your right. It is page 35, Lordship may see, para 21 of the appellate court judgment. Because what finally the court has said. Hmm. Yes, super.
Okay.
So Lordship may please come to page 20.
You contended since the suit ultimately has been dismissed, there is no scope or no requirement for you to challenge one part of the issue
Yes.
which might have gone against you.
Yes.
Because ultimate result is dismissal of the suit.
Dismiss. Because that is why I want to show, Lordship, because the trial court judgment is upheld by the appellate court. So Lordship, see the page 21. Page 21,
2-1.
case 2-1.
Yes.
Nasiketi.
Hmm.
Order. In view of the above facts and circumstances, suit of the plaintiff is dismissed.
That we have seen.
However, no cause. So this suit is dismissed. Now Lordship may come to page 35.
3-5.
35.
Yes.
Para 21.
Hmm.
In view of the above finding, the appeal is dismissed.
No, those are clear. Those are clear. No problem.
So, in that view of the matter, whether finding is there or not, it will not materially affect my right. Because it is for the plaintiff to take help of just finding and file whatever he want to do. I am not here to suggest Lordship, but the Lordship, here it is a clear case that plaintiff has not established his right, title, interest, nothing. If that being so,
Okay.
Lordship, it is 2014, 2 SCC, page 269.
2014.
2 SCC, page 269. I will not read the whole thing, Lordship. It is the para 13, 14, and 15.
Please read 13.
Mr. P.S. Narasimha and so Patel, learned senior counsel appearing for the respondent, submitted that the city civil court as well as the high court have correctly appreciated and they understood the legal position.
I think 15 will be the
15 is the answer.
15 is the answer.
15 is the answer. It is the trade law that this suit for declaration of title, the burden always lies to the plaintiff to make out and establish a clear case for granting such a declaration, and the weakness, if any, of the case set up by the defendant would not be a ground to grant relief to the plaintiff. That is my case, simply, Lordship. Lordship, it is 2019, 6 SCC, page 82. must have been argued that there is admission and all that. In some portion, the court has written also that there is an admission.
2019.
On the part of the admission lordship of the defendant lordship, because it's
2019 6 SCC 82.
2019 6 SCC page 82. lordship.
Yes.
It's a huge judgment lordship. I will not read everything lordship, only para 15. Para 15 at page 90.
90.
90.
Yes, please. Yes.
Section 58 of the Evidence Act, no doubt, postulate that the things admitted need not be proved. However, the proviso of the Section 58 of the Evidence Act gives a full discretion to the court to require the fact admitted to be proved otherwise than by such admission. When the respondent plaintiff had filed a suit for declaration of their title, the respondent plaintiff cannot isolate few sentences of the written statement and take advantage of only those parts of the written statement which was favorable to them. The written statement filed by the appellant defendant has to be read in toto. It is pertinent to note in the para 2 of the, so it is the, in my written statement, lordship, I said that he is my owner. He is my owner. It is there. They said that it is an admission that he has title and all that. My lord, it is the Rayati Khatyan, his name is there. So it is my paragraph. I said that in the Rayati Khatyan, my name is, his name is there. Yes. Even today I will say that. Otherwise, under whom I am the riot? I am the riot of the plaintiff. Because in the Rayati Khatyan, his name is there. That is exhibited. Lordship, lordship, may please come. His name is there. Exhibit call, lordship.
Yes, we have noted.
Lordship has gone.
And co has been discussed by the courts.
Yes, there is. And lordship in the Jamabandi, even now in the present Jamabandi also, it is shown lordship, my name and his name. I have been shown as a riot. In the press Jamabandi also, he was shown his name.
Okay.
Lordship, that day I have shown some judgment. If subsequently want that the lordship has given
I
it
think
back,
we have noted your judgments. Just a minute, please.
I can do one by one. Lordship. It is the 2019 11 SCC, case 309.
Just a minute.
Photo thing negative. Digital.
Doesn't DNI.
2019 11 SCC, case 309.
Regarding
Regarding that if he has possessory title or whatever he want, he have to prove his case.
11 SCC 309.
Page 309.
Para 19 and 21.
Para 19 and para 21. Page 316. Relevant page 316.
19.
Relevant page 316. Para 19. That lordship, the lordship has said that plaintiff have to prove his own case for the satisfaction of the court.
Yes.
He cannot succeed in the weakness of the case of the defendant.
Yes, same thing.
Yes. Then the 21, the conclusion arrived at the report.
Vasavi.
Yes, it is
2014.
same. The wording is same. And then 21 lordship, because he had the possessory title and all that was. Yeah. Yeah. Para 21.
Okay. Very much.
Photo teacher. Then Lordship, the 1956 SCC online, page 14, page 14.
This is AR 56.
Yes, Lord. This is AR.
AR 1956 Supreme Court.
AR 1956, page 593. Because I have taken the printout, Lordship, sometimes the paragraphs are different. Lordship. Yeah, I have one book. Yesterday, when I started reading, and the paragraphs are not the same. So now, Lordship, may please come to para 16. Para 16.
Hmm.
An admission is not conclusive as to the truth of the matter stated therein. It is only a piece of evidence. The way to address in which they must depend on the circumstances under which it is made. It can be shown to an erroneous or the untrue, so long as the person to whom it has been made has not acted upon it to his detriment, when it might become conclusive by way of estoppel. In the present case, there is no question of estoppel, as the title of so-and-so arose under the process has been transferred to admission 1932 and the subsequent year. In my case, it is a clear case, Lord. I said that he is my owner and I am Israel. So what is admission lordship? That is not the admission lordship. It is not the conclusive. And lordship, regarding in the last point, lordship, he has argued showing an Himachal case that that order 26 rule, and lordship, that lordship knows that is someone to file an application. And it is, if the
No, we have read the provision, whether we
provision
are,
is very clear.
whether we are considering that matter or not, it's a different, but that does not essentially require that it has to be done only on an application.
No, no, but the court, it is for the court satisfaction.
Court
itself.
satisfaction. No, what Mr. Deka is trying to impress is that when the remand order was on a specific issue,
It is
the
not.
initial remand order by this court was on a specific issue that the land was not, it was not discernible of the description of the land.
Court
So
will-
the matter was
court will
remanded
never-
back.
Court will never bring the evidence for this party.
No, no,
It is not the duty of the court.
listen to the court. You are right in contending that while remanding, no fresh issue was
No,
formulated. It was
Yes.
directed, remanded to decide the entire suit.
Entire
As it is.
and there,
But,
Yes, it-
but,
yes.
to contend that Order 26, Rule 9 powers can be exercised only on an application, perhaps that may not be a
no,
correct.
no, that is not. That is what I want to show, Lordship. Lordship, at the 1976 ALR, page 125. I know Lordship will write a judgment, so I thought that the, at least
ALR, page,
1976 ALR, page 125. The Honorable Justice Kiranmoy Lahiri's judgment, Lord.
para,
Para 12. Because Lordship has read the provision. So now the para 12, what is it? Let us see.
this is Vidyadhar Bora.
Yes. And Lordship, I want to point out only one thing, Lordship, if Lordship allow. If Lordship allow me,
Yes, yes, please.
in the second page, page 176. 176.
176.
No, Lordship, it is 126, Lordship. 126.
126. Yes,
Lordship, Lordship, get it.
yes, yes.
My father and Lordship's father, both of them appeared in this case. After long 76 and now Lordship, we are 24. Lordship, today we are arguing, Lordship, I am arguing before Lordship. Both of them have appeared in this case.
Pleasant coincidence. Yes, paragraph?
Para 12.
Yes.
The expression, the court deemed in this state rule is a pointer that the satisfaction as to the issuance of commission is entirely that of the court and not those of the parties to the suit. It is the court satisfacting the court will send it. The rule does not give an absolute right to any of the parties to get an order in his favor. It is the This is the spirit of this Order 26 Rule 9 law. It's not the Himachal Court law. This is our High Court judgment. Then Lordship 2018, 3GLR, page 811. Lordship, the paragraph 34, 35, 36.
Just a minute, please.
I'm sorry.
Two thousand
2018, 3GLR, page 811.
paragraph.
Paragraph 34, 35, and 36. Lordship, on the day one, Lordship has referred to this section 54 of the Act. And here it is said that the section 54 provides for procedure for ejectment. Section 54(4) provides that no suit for ejectment on the ground mentioned in the section 51(2)(c) shall be entertained unless then so. So it is that 54 part clause. Lordship, that Lordship, I need not read this part because Lordship knows better. So ultimately, Lordship, at the page 33,
Yes.
page 33, para 19 of the judgment. Appellate court judgment.
Yes.
The plaintiff claimed that they are the owner of the schedule A schedule, they are the owner of A schedule land, and the B schedule is part of the A schedule land. The plaintiff side had not exhibited any document regarding their ownership over the A schedule land. The admission of the defendant that the plaintiffs are the owner of the land over which he has obtained tenancy cartian does not itself make the plaintiff owner of the A schedule land. The plaintiff must have produced and exhibited document showing that they are in fact owner of the A schedule land. Had there been any revenue record before the court showing ownership of the plaintiff over the A schedule land, the court would have compared. That is my point, Lordship. That day also I pointed out. With what document the court will compare? Compare the Lordship, whether this is my land, this is his land, or whether this is a different plot of land and my land is different plot of land. That is not before the court. You would have compared that whether the land over which the defendant claimed to have obtained right cartian is same as B schedule land or not. The plaintiff have sought declaration of right title interest over the B schedule land, which they claim to be a part of the A schedule land. Hence, the plaintiff have to prove first that they are the owner of the A schedule land. There is no document from the plaintiff side in support of the claim. The plaintiff will not automatically become the owner just because the defendant has said that the plaintiff are the owner of the land over which the defendant has got tenancy right. I find that the plaintiff have failed to prove that they are the owner of the A schedule land. As such, I find that the plaintiff are not entitled to any relief. Issue number 3 is decided in the negative in favor of the defendant and against the plaintiff, I find that the plaintiff appellant have not been able to prove that they are the owner of the scheduled land, so and so as part of the AC. So this is the finding, finally. And the Lordship, I have read that para 21 in view of the above finding, the
Yes.
appeal is dismissed with contest with cause. And the para, they do it, page 21. Page 21, the suit was dismissed and that judgment of the trial court was up. So that's my real.
Okay.
Lordship, only one point, my lord, from my senior submission, my lord. This honorable court, my lord, under
Mhm.
what this honorable court on earlier occasion, my lord, under what circumstances has remanded this matter, was the stand taken by the defendant side on the page 42 para 9, my lord, of the this honorable court earlier. Page 42 para 9, my lord. What is the since court has prima facie, my lord, paragraph 7, this honorable court earlier held that there is a discrepancy. Therefore, my lord, on that point, my lord, what the submission may defendant, therefore the respondent has fairly submitted that on the face of the record of the case, the description of the suit land basically does not tally with the writing had been relied by the defendant. To such extent, it is necessary to record a finding of fact as to whether both the lands are, it is the defendant's submission, my lord, different or the same plot of land. So senior counsel submits that there are a material available record to show that both the plot of land, one and the same. Therefore, my lord, since the proof, my lord, paragraph 7 of this honorable court before this court, yes, absolutely. To
This
defend land,
this
yes,
submission is by whom? The,
my lord, from defendant side, para 9, and appellant side, para 8. After paragraph 7, my lord, this submission, my lord, sir. That
okay.
even from defendant's side admitted that the land claimed by the defendant is a different from. Therefore, my lord, observation in the paragraph 10. Under what the question involved?
Oh,
Yes, my lord. I specifically say that I am therefore of the view that the learned court below was not correct in dismissing suit without ascertaining the said aspect of the matter. Without ascertaining, that means the court has to ascertain first the land is the claiming the tenancy, the land claiming that the plaintiff is the same or not. But absolutely abundantly failed by the appellate court on this point, my lord, and discussion and the title of this is not the issue, my lord. Therefore, my lord, this honorable court had remanded by directing them to decide on this point only, my lord, and abundantly failed by the landed trial court below or relying on the statement of the whatever paragraph statement in paragraph 8, whatever statement made in paragraph 13, but only on the basis of that, this as well. My humble submission is absolutely the case of method for interference with some court remanded back to a certain as per law, my lord. Oblige me.
Heard. P.K. Declared counsel for the appellant, whereas the respondent are represented, respondents are represented by Sri S. Sharma and senior counsel assisted by Sri T.K. Bhuya. The hearing is concluded, the judgment is reserved. Okay. We'll consider.
I'm grateful of.
Oblige me.
Note video taken.
May I appeal? Okay, I apologize.
Yes.
Lordship, East Division Petition, Lordship.
against the judgment of Planet District Judge Lordship by partly reversing the judgment of Planet Trial Court under the Assam Urban Area Rent Control Act.
You are what?
I am the senior defendant, Lord.
Petitioner is the defendant.
Petitioner is the
Suit for ejectment.
ejectment, Lord. On the ground that default in payment, Lord.
Defaulter.
Defaulter, Lord.
Then what was the decision of the first court?
First post lordship did not hold me defaulter, but directed to adjust the security deposit and to pay the balance amount and to take possession from me, Lord. What happened, Lordship?
No,
in
no,
this
on
case,
what ground? If, you see, you are protected by section 5
Lordship,
and there are only certain exceptions
Lordship,
when a tenant can be ejected.
Lordship,
Now, you said that the suit was for ejectment on the ground of defaulter.
defaulter, that,
You are held to be you are held not to be defaulter.
no, Lord.
Then
What happened, Lordship, in this case, the suit of the plaintiff was that I paid that amount through check, Lord.
Hmm.
There is some collection charge levied by the bank from the plaintiff,
Yes.
and that collection amount, they have claimed that it is the amount due from me, so I was defaulter in rent for that amount. Second thing, Lordship, for 3 months rent, I have paid together, Lordship. They also accepted without any protest. For that 3 months, Lordship, they have levied 18% per annum per month, Lordship. That amount
80% or what?
has 18% of the rent amount.
Okay.
Rent was fixed on 12,100 Lordship. I had paid 3 months rent together in one slot. They have accepted. It is a prior to TS back. At the time of filing this suit, they have also calculated 80% per annum to interest on that point, and they have claimed that that amount was due from the defendant to plaintiff. Third issue is that I issued a statute notice of a termination of tenancy, Lordship in the month of April 2008. 3 month notice. And
Yes,
asked
now, yes, this point we did not get you. Last point, what was it?
last one is that from Lordship December 6 to June 2007, monthly rent, I have paid Lordship
Hmm.
together by the check, and he has also accepted it.
No, that 18% we have understood. The last one, last one.
Last one, Lordship, in the month of April 2008, Lordship,
Hmm.
29th April 2008, 28 April 2008, I have served a notice of termination
Hmm.
as per the terms of agreement, Lordship.
You served.
I served, Lordship. Just we are going to vacate the premises
Hmm.
on commencing that completion of 3 months, Lordship, which should be completed in the month of July, Lordship.
Hmm. Then,
Then, Lordship, he replied by raising this demand, Lordship, that you paid clear this amount, then only we will accept. And if this suit is filed, claiming this rent also, Lordship, that notice period rent also.
no, but
And from to 28 July,
April 2008, you had served the notice.
Lordship,
3 months
3
notice.
months notice, Lordship.
That you did not vacate in April.
No, in the end of the
April-
July, Lordship.
Then aren't you required to pay rent?
Rent, Lordship.
Then,
But there is a adjustment clause also,
Okay, you had 3 months advance.
advance also.
Okay. Okay, then now what is the,
And
what are
after
the
last
findings?
pair was that from 28 July 2008, after completion of the tenancy,
Hmm.
termination notice period also,
Hmm.
I was in occupation. So he demanded 77,644 as illegal, terming me it as a illegal occupation. That was the suit process. Lanet Lanet trial judge Lordship partly dictated the suit, directing me to adjust the rent and the balance amount to be refunded to him. That 2,000 for damage or claiming some damage in wear and tear of the building.
No, the last from 28 July 2008,
Lordship.
you were in possession Till what time?
Yes,
Till
Lordship,
what time?
I asked him to take over the possession.
He did not.
He did not turn up.
When did
So-
did you vacate the premises?
Yes, I have informed that for safe custody of your premises, I am keeping a lock.
Hmm.
You are ready at any time to take back that.
When
lock
did you practically vacate the premise?
On the date of termination, Lordship, 28th of July, Lordship.
Okay. Now the third, claim is for rent from July 2008 to
To December 2008 till filing of that suit.
July to December 2008. They are asking for rent
Rent,
at the
Lordship.
rate of
At the rate of Lordship, that enhanced rate of 25%, Lordship.
at the rate of
15,125, Lordship. There was a clause that after completion of 3 years, there would be escalation of 25% of rent, Lordship.
in December the suit was instituted,
Lordship,
and at that time they had taken possession.
Lordship.
They had
Lordship, they have from December till the date of filing of the suit, they had did not turn up to take the
no, in December.
December, Lordship.
December they took possession. From July to December 2008,
Lordship,
you said that in spite of your intimation,
Lordship, you have not turned up.
they did not take over possession, and on filing of the suit they had taken over possession, and in this period they had asked rent for at an enhanced
So,
rate.
Okay.
Okay. Now what are the decrees?
Lordship, decree passed by the page 34, Lordship, in the trial judge, the plaintiff is entitled to
30,
the relief
30,
mentioned in paragraph of
34.
13A and B.
Paragraph
34.
Page 34.
34 is the operative part, Lordship.
Just a minute. It is by whom? Civil Judge Kachar, number
Civil
one.
Custard, Lordship, number 1.
This is, what
That
is the date?
plaintiff is entitled to
Is
the
it
relief.
12th day of July?
Lordship, paragraph, yes, Lordship.
12 July 20,
12
2000.
11, Lordship. Plaintiff is entitled to relief mentioned in paragraph 13A and 13B. If that, fair Lordship would find paragraph 14, page 14.
Page 40.
No, Lordship,
Page-
1-4. That pair of the relief sought for in the plain,
Hmm.
page
Which
1-4.
Number?
1-4, paragraph 13.
No,
Page
13.
one.
And then which
Page
which
1-4.
prayer? Which prayer?
The last Lordship, 13. The plaintiff therefore prays
No,
for a
that we have
decree.
understood. Which of the prayers? A, B, C, D.
A,
which one?
B, A and B was
A and B.
allowed.
A and B.
For ejectment of the defendant and any person claiming under them from their illegal occupation and premises described so for direction upon the defendant for removal of all furniture, fixture and so at its cost and restore the scheduled premises as it was when it was took possession to the same and so
Okay. A and B allowed
and allowed, Lordship.
by the trial court.
Trial court,
The
Lordship.
rest of the relief?
No, Lordship, that is not paid up. Plaintiff is not entitled to the relief mentioned in the rest of the pair portion of the plaint.
Hmm.
Further, defendant is directed to compensate an amount of rupees 2,000 to the plaintiff
Hmm.
from the advanced amount of rupees 36,300
Hmm.
as cost to the plumber, and plaintiff would return the remaining balance amount after deducting 200 from 36,000.
2000, not 200, 2000.
2,000,
Hmm.
sorry. 2,000 from rupees 36,300.
Okay.
That was challenged by the plaintiff
In-
before the
In the
district
first
judge.
appeal.
District judge, Lordship,
Hmm.
has partly reversed, Lordship. That party portion, Lordship.
Yes.
Page 44, Lordship.
4-4.
4-4. 11, Lordship, paragraph.
This is dated
Lordship,
15 July.
15 July 2013, Lord. In view of the discussion, Lordship, get it?
Yes.
In view of the discussion, the appellant plaintiff is entitled to the relief paid for in paragraph G and H of the plaint.
You are at
However,
page
44, Lordship.
44. Yes.
In view of the above discussion,
Paragraph
11, Lordship, Roman 11.
yes.
In view of the above discussion, the appellant plaintiff is entitled to the relief paid for at paragraph 13G and H of the plaint. However, it is clarified that although the word compensation has been mentioned in paragraph 13H, what the appellant plaintiff is entitled to is a decree for unpaid rent from the period 28 July so per month till the defendant vacate the scheduled premises and nothing over and above that as compensation for the period, as there is no provision for compensation under the Assam Urban Area Rent Control Act. The plaintiff appellant is also entitled the interest at the rate of 6% on the total sum received from the date of institution of the title suit be realized. The learned trial court, while partly decreeing the suit for eviction of the defendant from the suit premises, further decreed that the plaintiff shall return the security deposit of 36,300 to the defendant after deducting 2,000 as cost to the plumber. I find the above direction is to be wholly illegal in the absence of any set of counterclaim having been made by the defendant. Rather, the defendant in their written statement sought leave of the court to file a separate suit for realization of the above amount. In view of the discussion made above, impugn judgment and decree except the decree of eviction is set aside and appeal is allowed with cause. The suit is decreed to the extent indicated above, draw up the decree accordingly.
Yes.
So, Lord,
Now, ultimately, what is the ultimate result?
ultimate result, Lordship, as per the terms of agreement,
No, ultimate result of the appellate court judgment.
appellate court judge, we are bound to pay 77,600
As being the
being the monthly rent from 28 July to December 2008.
net result. Okay, net
Okay.
result. December from July to
July 2008 to December 2008. And also
that will come to
December 2008.
rupees come to
15,125.
at the rate of 15,125.
125. Lordship.
It will come to how much?
Lordship, 77,642.
Okay.
And also, Lordship, A, for declaration, the plaintiff is entitled to compensation at the rate of 15,125 per month from the defendant for the illegal use of occupation of so and so, along with all electrical charge in respect of silver until
Which
defendant
one?
vacated the so and so.
H is what?
H was for declaration that the plaintiff is entitled to compensation at a rate of 15,125 per month from the defendant for the illegal use.
No, but there is nothing above that. As
Lordship.
compensation for there is no provision. That is
Yes.
not payable.
Just cannot. But that was granted. Lordship.
No, that is not been granted. In
Paragraph
11,
paragraph number 13 and H was granted.
no, however, it is clarified. Why didn't you read the entire thing? The compensation part has been denied.
Yes.
Because there is no such provision in the Rent Control Act.
Hmm.
Compensation is not there.
Lordship.
That is why the clarification is there. That part is not there. So net result is payment of 76,
Lordship,
77. And
Lordship.
what about your 36,000, which was this advance?
Yes, it is mentioned in lordship. It exhibit 1,
No. What would be the net result? The learned first appellate court has held
yes,
that in absence of a counterclaim
lordship,
to set off,
lordship.
that could not have been granted, the
Lordship,
adjustment.
yes, but I have not paid for that counterclaim for setting up that amount loss. But there is a lordship, settle law, when the amount has been paid as an advance or with a security deposit with a provision of adjustment, that can be adjusted by the landlord from the.
No, what would be the next net result? They retained is 36,300.
Yes, lordship. They have
That
not.
will not be adjusted.
Not, they have not, it is still in their position.
No. The net result of if the appellate court judgment is upheld,
Lordship,
or as per the judgment of the first appellate court,
lordship.
they will retain this 36,300.
Lordship, from the net result of the decree of appellate court, lordship, they will have to refund me 36,000 and I will have to pay that 77,000 something amount which as per 13G, as I have
Yes,
understood.
Yes. 13G, what is 13G?
Lordship,
Page,
page lordship 15, lordship. Page 44, that 13G was page 14. Oh, sorry, 15. That's 77,642.
No, there is nothing regarding this 36,000. How is this 36,000 being adjusted?
Plus 36,000 is a admitted amount as per the agreement. There is a 36,300 amount was paid from the defendant to the plaintiff at the time of
No,
commencement
those
of
we have
the
understood, Mr. Datta. We are on much
Yes,
advanced thing. We are not on the basics.
lordship.
The appellate court judgment has said that since there was no counterclaim for setting off,
Yes, lordship.
that observation regarding adjustment of 36,000 has been set aside.
Lordship.
Now, what is the net result? That's 36,000 will be retained by them.
As per agreement, they are to be.
We are not on the agreement, Mr.
Oh, yes, lordship.
Is the agreement enforcing the agreement?
Yes. From the.
We are from the from the perspective of the
lordship, there was
judgment.
No direction.
As per the judgment, they will still retain.
No direction, lordship.
They will retain it.
Yes.
There will be no adjustment.
No judgment, no direction from the appellate court. Lordship. But it was in the trial judge. Lordship.
Yes, Mr. Laskar, you cannot make a windfall. Even if we hold that you are entitled to 77,642, even if you do not interfere with this finding, it is a matter of fact that you had an advance of 36,000. Where will this amount go?
My lord, subject to, my lord, correction, my lord. Page 43, my lord.
43.
Lordship,
Yes.
Roman 10, my lord.
Yes.
Married.
Hmm.
The defendant by the notice of submission dated 28/4/2008, Exhibit 3,
Yes.
had asked the plaintiff to take possession of the suit premises by refunding this security deposit of rupees 36,300. The defendant by the aforesaid notice also agreed to pay all outstanding dues to the plaintiff.
Hmm.
The plaintiff by her letter dated 8/7/2008 to the defendant, Exhibit 4, claimed certain amount as outstanding dues from the defendant and agreed to refund the security deposit on the unadjusted portion of the same, subject to payment of the outstanding dues and performance of its obligation under the lease agreement by the defendant. The plaintiff SPW1 also deposed in her examination in chief that she was ready to refund the security deposit on fulfillment of the above condition.
Hmm.
However, as discussed herein above, the defendant failed to pay their outstanding dues to the tune of rupees 39,326
Hmm.
by the end of
Now,
July.
Mr. Laskar, now you have a decree
Hello.
by which the defendant is directed to pay an amount of rupees 77,000 whatever,
Hello.
being the rent from July 2008 to December 2008 at an enhanced rate.
Yes.
Enhanced rate. Let us assume that we are not interfering with this. This will be paid to you, but there is no observation regarding adjustment with the advance payment. Advance payment you are required to refund.
Exactly, my lord, your lord. But my lord, I want to say, my lord, the adjustment, my lord, planet appellate court below, my lord. Hence, after adjustment, nothing was due to the defendant as an adjusted portion of the security. Planet trial court has held that, my lord, appellate court has held that after deducting, my lord, 36,300, my lord, out of the tune of rupees, my lord, 77,000 mentioned in 14 months. Hence, after adjustment, nothing was due to the defendant as an adjusted portion of the security deposit. But since the defendant has made repayment of the security deposit amount of rupees 36,300, a condition precedent to the handing over of possession of the suit premises to the plaintiff, it would have been a futile exercise for the plaintiff to go to the defendant to receive possession of the suit premises. That's another thing, Malad. But
No, that was what was happened earlier.
My-
Now you have a decree
Hello.
whereby you would be receiving rent at the enhanced rate from July 2008 to December 2008. Now that rent would be paid. This is nothing to do with the 36,000, which was the advance payment. Now, if you are saying that it should not be adjusted, then you have to refund it. You cannot get a windfall.
after adjustment, Malad, refund money, Malad, advance money cannot be.
This 77,000 has been worked out by taking rent at the rate of 15,125. That is the enhanced rate.
Enhanced.
Even if you do not interfere, you have to refund this 36,000. You cannot get the rent and you can also usurp or appropriate this 36,000. That was the advance payment. Either 36,000 has to be adjusted with 77,000 or it has to be refunded back. Same thing.
Malad, plumber compensation of.
Plumber 2,000 they are
2,000,
paying.
2,000.
They are paying.
Fine.
They are paying.
That is,
They are paying. 2,000 we are not saying anything.
Yes.
Yes, what do you say?
Yes, sir.
Okay. We
Malad,
are not going into the aspect of July to December.
Fine.
Since we may go into that aspect since they had not taken our position. And out of compulsion, you had to put a lock for the safe custody. But we'll not go into this aspect. 36,000 will be refunded to you. Have you paid the amount? No.
No, Lord.
Malad, now present status, Malad, as I have got it back from my client,
Yes.
delivery of past position, Malad, to suit premises. It's already been delivered by the.
That was in December 2008 itself.
We have got now.
Yes. That was in December 2000. Otherwise, you'd have made your claimed more amount than this
Yes, sir.
July to December. That okay.
Malad, being aggrieved by the judgment decree, Malad, passed by the land trial court, we have preferred appeal, Malad. But the rest of the prayer, Malad, that has not been done by the land trial court. The appellate court, Malad, altogether decreed, Malad.
That we have seen.
Without-
That is why they are in revision now.
But- Malad, the set of a counterclaim that has not been preferred by them.
What was the rent, Mr. Dutta, originally?
12,100 proceed.
Therefore, 36,300.
Yeah. And it was a condition on renewal that could be enhanced to 25%, because the rent was, agreement was not renewed. But
Yes, please have your seat. The instant petition has been filed under section 115 of the Code of Civil Procedure 1908 against a judgment and decree dated 15/7/2013 passed by the learned district judge Kachar in title appeal number 3 of 2011. Full stop. By the impugned judgment and decree, comma, the first appellate court had partly reversed the judgment and decree dated 12/7/2011 passed by the learned civil judge number 1, Kachar, in title suit number 64 of 2008. Full stop. Since the Urban Areas Rent Control Act does not provide for any second appeal, comma, the application has been presented to invoke the revisionary jurisdiction of this court. Para. The petitioner is the defendant in the suit, in the entitled suit 64 of 2008, which was instituted for ejectment of no, the suit was instituted last order. This for ejectment and other relief. The case projected in the plaint, the facts projected in the plaint was that the defendants duta ase ha, defendants hobo ha. The defendants were the tenants in respect of the suit premises at a monthly rent of rupees 12,100. And such tenancy had started from June 2005. Full stop. It also transfers from the record that the defendants had made an advance payment of rupees 36,300, being 3 months rent. Full stop. In April 2008, comma, the defendant had served a notice of termination after 3 months, which was replied to by the plaintiff. Full stop. Though, as per the defendants, comma, on 28 July 2008, the premises was vacated, comma, the plaintiff had failed to take over possession, and therefore, for its safe custody, comma, the defendants had put a lock. Full stop. The suit was ultimately instituted by terming the defendants as defaulter. Full stop. It appears that the issue of defaulter was also connected to certain amounts relating to bank charges, as the payments of rent was made by check. Full stop. It also transpires that for one occasion, comma, the defendants had made payment of 3 months' rent together, and the default was attributed to a claim of interest at the rate of 18% for those 3 months. Full stop. Those 3 months from December 2006 to June, no, it not be June. 3 months you have said, December, January, February. Why are you saying June?
No, Lordship, it is,
Or was it 6 months?
6 months,
6 months.
6 months.
6 months. Huh?
December 6 to June 7.
To June 2007. 3 months now, 6 months. Huh? Para. The learned trial court vied the judgment dated 12/7/2011 had decreed the suit only for prayers numbers A and B, and the rest of the relief was denied. Full stop. For ready reference, comma, the relief sought under A and B are extracted herein below. Page 14, A and B, 13 of the my page wrong. Para. Being aggrieved, comma, the plaintiffs had preferred the appeal being title appeal number 3 of 2011 before the learned district judge Kachar. Full stop. The appellate court vied judgment and decree dated 15/7/2013 had also granted the relief under prayer G and prayer H, and also interest at the rate of 6%. Full stop. The learned appellate court had also interfered with the issue of adjustment of the advance payment, as there was no separate counterclaim for set off. Full stop. Para. I have heard Sri P.P. Datta, learned counsel for the petitioner. Full stop. I have also heard Sri T. U. Laskar, learned counsel for the respondents. Full stop. The Sri Datta, the learned counsel has submitted that there is no dispute to the fact that the premises in question was ultimately taken over possession by the plaintiff in December 2008. Full stop. He has, however, submitted that the claim for rent and the direction of the first appellate court for such payments of rent from July 2008 to December 2008 is not justified, as in the aforesaid period, the defendants were not in possession. Full stop. It is submitted that the premises in question was vacated by the end of July 2008, and peaceful possession was sought to be handed over to the plaintiff, which was refused by him, and only for the safe custody, the defendants had put a lock in the premises. Full stop. It is submitted that by the aforesaid action, it cannot be held that the defendants were continuing with the possession of the premises in question. Full stop. It is submitted that rent would be payable only when a tenant is in possession thereof and not otherwise. Full stop. Para. The learned counsel for the petitioner has also submitted that the direction of the first appellate court towards the issue on the issue of adjustment of the advance is against the interest of justice. Full stop. It is submitted that the rent agreement had a specific clause of adjustment / refund of the advance payment, and therefore it was incumbent upon the landlord to abide by the same, for which no counterclaim would be required. Full stop. Sri Datta has, however, submitted that so far as the direction to pay rupees 2,000 as damage, the petitioners would not have any grievance. Full stop. The learned counsel accordingly submits that the impugned judgment is required to be interfered with. Full stop. Para. Per contra, Sri Laskar, the learned counsel for the respondent plaintiff, has submitted that the judgment and decree of the first appellate court dated 15/7/2013 has been passed after consideration of all the relevant materials on record. Full stop. It is submitted that a clear case of default was made out, and since the possession of the premises in question was not handed over in July 2008, it was incumbent upon the defendants to pay the rent. Full stop. The claim for enhanced rent has been made in terms of the specific clause in the agreement which prescribes for an enhanced rate of
25%,
15%,
25%.
25% after expiry of 3 years.
3
3 years
And on renewal.
and on renewal, full stop. It is submitted that the direction towards payment of interest is also justified as the amount was a legal entitlement of the plaintiff respondent being the landlord. Full stop. Para. On the part of the judge, impugn judgment towards adjustment oblique set off of the advance amount of rupees 36,300, the learned counsel has submitted that the first appellate court was absolutely that the observation of the first appellate court is in accordance with law, as there was no counterclaim or any statement for setting off. Full stop. Para. The rival submissions have been duly considered. Full stop. The records, the LCR has also been duly perused. Full stop. Para. Certain facts which are undisputed emerge from the materials on record. Full stop. The defendants, the petitioner's defendants were the tenants of the plaintiff in respect of the suit premises at a monthly rent of rupees 12,100. Full stop. As per the agreement, rent agreement, there was also a provision for enhancement at the rate of 25% after 3 years upon renewal. Full stop. The materials also suggest that the petitioners had served a notice of termination of the tenancy in April 2008. Full stop. Prior to the, it was only thereafter. However, the defendants, however, the petitioners' defendants have projected that in spite of the notice, the possession was not taken over, and only for the safe custody of the premises, the defendants had put a lock. Full stop. Para. It appears that the suit was instituted towards the end of the year 2008, wherein the aspect of default was also taken. Full stop. The default, as observed above, is on the aspect of bank charges connected to payment of rent by check and interest charges for rents paid together for 6 months. Full stop. There was no such demand. There is no such suit instituted at a prior point of time. And it was only after the expiry of the notice period. Full stop. It is also not in dispute that the possession of the suit premises was ultimately taken over by the plaintiff respondent in December 2008, whereafter the suit was instituted. Full stop. This court is of the view that so far as the judgment dated 12/7/2011 of the trial judge is concerned, granting prayer A and B are concerned, comma, the same appears to be in order, full stop. The grievance of the present respondent before the first appellate court was in respect of denial of the relief, denial of the other reliefs, full stop. The first appellate court had also taken into consideration the aspect of possession from July 2008 and to December 2008 and had granted and had directed payment of an amount of rupees 77,642 being the rent at the enhanced rate of rupees 15,125 per month. Full stop. The learned first appellate court had also directed payment of interest at the rate of 6%. Full stop. The first appellate court has, however, made an observation on the aspect of adjustment oblique renewal of the advance amount of rupees 36,300 due to absence of any counterclaim. Full stop. Para. Though taking a hyper-technical view, comma, the aforesaid observation is a possible and plausible observation, comma. Interest of justice would demand that such a requirement may not be strictly adhered to for adjustment of the advance amount which was not otherwise disputed. Full stop. It would be against the interest of justice to deny such adjustment oblique refund when admittedly the amount of rupees 36,300 was paid and lying with the respondent as advance payment at the time of induction of the petitioners as tenants. Full stop. Para. In view of the aforesaid discussions, comma, while this court is not inclined to interfere with the impugned judgment and decree dated 15/7/2013, comma, the part of the judgment denying the adjustment of the amount of rupees 36,300 stands interfered with. Full stop. Accordingly, comma, the payment to be made by the present petitioners in terms of the impugned decree would stand adjusted by the amount of rupees 36,300. Full stop. The appeal accordingly stands disposed of in terms of the observations made above. Rest you'll get 6% everything, 2,000 everything. Okay.
After adjustment.
Yes, only 36,300 will be adjusted. Okay.
Okay.
Yes.
Apply.
Mr. AG, why are you here?
For my learned friend's third lordship, I have to make my submission. In this case, I am appearing for one of the associates.
Oh, that matter. Yes,
That matter.
yes, they had paid for,
In fact,
but there is an objection. That
yes,
is why we
yes,
have to.
yes, yes, Lordship. So my assisting counsel Rajiv Borpujari, Lordship, he is in Calcutta representing in Assam government's matter, assisting the additional advocate general Dilip Murty.
Okay.
So that's why my assisting counsel is also, let them start if they have some.
See, since there was an objection, we said that we'll let the matter reach. We are
Lord.
not said that we'll go ahead with the matter.
Lordship.
But there was an objection. We can we'll have a short date.
No.
What
yes,
is the
Lordship.
objection for?
Lordship, we'll have a short date. Lordship, the matter is this, if Lordship sees to the orders, and since 5 years, they have been enjoying the interim by submission of fraudulent documents. I don't want to put it now. When the matter comes, I'll show it to
What
you.
is the matter about? What is the appeal about?
The appeal about is this, it's the interim order they have challenged of the trial court. There's a trial court order,
You're the plaintiff.
I'm the plaintiff.
Plaintiff play suit for? Suit for?
Challenging the de-affiliation of the organization, the association.
Your association was de-affiliated.
Will de-affiliated.
You have challenged that.
Yes, Lordship.
And there was an interim order,
There was an interim order,
injunction,
injunction,
in the form?
in the form that, de-affiliation was stopped and whatever prayer we had prayed
Okay, that interim order is the subject matter.
of this APAO.
You are the
Okay.
respondent here.
Yes, I'm the respondent here. So I have come for vacating the petition. Vacating.
What is the nature of the interim order passed or
Yes.
here?
Lordship. It's a nature of a final disposal only, the interim order. It's in the nature like they have come against the interim, they have come against the interim order passed by the civil court. Here this honorable court has passed an interim order, putting a halt.
No, the injunction has been stayed.
Your Lordship,
Injunction has been stayed.
Lordship.
What is the development in the suit?
Evidence going on, Lordship, it didn't even start properly. That is the problem, Lordship.
Now, from the filing of the suit, now you are still in the state of de-affiliated.
Lordship,
Now, by the injunction, you could have got the benefit of being
Lordship.
affiliation. Okay.
because we are, the AODA, All India Organization is a parent body and every state has only one
You are Assam Drug Dealers
Lordship.
Association.
Lordship.
Oh.
Since 1987, our organization exists, Lordship. So with a fraudulent, somebody.
No,
else-
we are not going on to
Lordship.
the merits. We are only on the ground, on the injunction.
Lordship,
What
only on the injunction.
materials
Lordship,
were considered
Lordship.
before passing the injunction?
Lordship.
And, okay, we'll have it on a date convenient to
Next
both.
week, Lordship, on Tuesday.
Next
pray on-
Next Tuesday, practically saying it will not be possible. Last
Let
week
it be
will be
on
there.
16th or 17th of.
Last
July.
week will be a motion day.
Lordship, it is, Lordship, if I say Lordship,
Mm.
I should not make such type of submission. Even the earlier councils have been changed because this Lordship. And that if Lordship sees, even there was an order of final hearing and last chance was given to them for final disposal of the case. If Lordship sees how many adjournments were taken,
No, we
Lordship.
are not going to do some
In
personal
fact, we have
difficulties there.
completed our arguments on 2 occasions.
No, it's only a matter of, we'll have it with the fixed date.
It was released from part, that is the difference.
We'll have an agreed date, don't worry.
16th of July. If it
No,
is not-
Lordship, it is too, I'll be not in station. That's why,
No, tell us when.
Lordship, on the last occasion,
No, tell us when.
this 16th or 17th, Lordship, next week, Lordship.
Next week, motion date will not be possible. Be practical.
Sunday.
This
No.
last week, it will be last week before the vacation. Will not be
Earliest
possible.
possible.
We are not fixing any hearing matters in the last week. We have immediately on the vacation.
That is
Mr.
the
Saikia
16th.
has the 16th as a Tuesday.
Yes, Lordship.
You'll be
Lordship,
there or not Tuesday?
I'll have to be there. I'll have to cancel. I have
No,
to be
no,
there.
you may make a date of.
No, Lordship, it's okay. It's
No, no,
okay.
you gave 1 or 2
Because of
days.
the last occasion, Lordship, I did not give my date. They had seen the diary and they had given the date. This is the call. I said I will not give the date. They both the senior advocates.
Okay, 18th.
Okay.
18th is okay.
Lordship.
18th, are you here?
Yes, sir.
18th. Okay. A prayer for adjournment has been made on behalf of the appellant, full stop. However, the said prayer has been objected to by the learned counsel for the respondent by stating that the appeal is of the year 2019 and that is an interim order, full stop. Para, be that as it may, comma, in the interest of justice, let there be another opportunity and the matter be fixed, be listed for final disposal, be listed on 18th of July, 2024, on which date this court will make an endeavor to finally hear the matter.
Lordship, may I pray, Lordship? Lordship may retain the matter.
Written, like,
Matter with Lordship, no?
there are roosters, madam.
I know.
Highly
It's the
obliged.
prerogative of the Chief Justice. Okay.
Anthony,
Item number,
My lord, it is an MSTC, my lord, for enhancement, because there is a wrong in the multiplier. And also, my lord, there is a double deduction of tax. That is the only 2 point, my lord. And my lord, very interestingly, I mean, till today, my lord, a ranger was died in a very young stage, but till today, nothing has been paid to me, my lord.
Mr. Ray for,
My lord, owner of the vehicle.
and insurance? Yes, madam. Multiplier. Is the owner anything settled on the owner? No.
That, that is paid. Order. And we have started. That's
Yeah, there is an,
Second. 3 years.
1 month here. So it should be 13. It should be 13.
no, see,
No,
madam, though both of you are on the same side, Mr. Rai and you, there will be a dispute between you two. Because you would be contending that since the owner was the driver, so the policy would not cover. But the compensation per se cannot be denied. It's only a question who will pay the compensation, isn't it? Now, your second contention is that pay and recover that is gone. That is not possible. No, that court was, that was by,
Yes, Salamamana.
that is it. That is not, that's the tribunal's finding you're challenging. There's no question of pay and recovery. If they are liable, they have to pay. That is also gone. Okay. Mr. Rai, everything will come upon you.
But yes.
Multiplier part first, we cannot, we'll go by the law.
Learned Tribunal has passed, when the liability on me, basing on the false, my lord, driving license. And your lordship, exhibit 1 of the case, my number has been given here from 54. My driving license number has been given. Even.
You are the
motorcycle
driver.
inspector- Yes,
You are the owner driver.
owner type.
And Mr. Mohanta, your client was, the deceased was? Mr. Mohanta?
He's a ranger, my lord.
No, he was, how was he connected with the accident? He was an occupant.
Roadside, my lord. It was
He was walking in the road, my
Oh,
lord.
you are a pedestrian, you were
Yes,
knocked
yes.
down. Okay.
It is.
and exhibit, my lord, 4.
And why is it not covered by your policy? Oh, driver did not have a driving license.
I have not received the notice from the tribunal.
How much is the amount, Mr. Mohanta?
My lord,
You will hear it.
amount 37 lakhs, 66,000, 378, my.
37 lakhs, and you are praying for enhancement because of
Enhancement
by
because multiplier is
use
wrong.
of correct multiplier.
Tag multiplier,
Multiplier of whom was used?
my lord.
Whose multiplier was used?
Yet here, my lord, it is, my lord, 50 years, my lord. That's
Fif-
why
The deceased was 50 years.
50 year, 1 month, 3 days.
Okay.
And that, but up to 50 years, my lord, okay, it is 13 years. But
13 multiplier.
13 multiplier. But it should not be treated as a 51. In my case, it should not be treated as a 51. You lordship kindly see, Mama is squarely covered to me, my lord. So that should be, my lord, maybe 12. Your lordship kindly see, para 42 of the,
What multiplier has been used?
use 11, my lord.
11 is for what?
11 is up to 50,
Up to 50.
my lord.
And for you are 50 plus.
50 plus 1 month, yes.
Okay, what multiplier has been used?
It should be, my lord, 12. Sorry, it should be 13, my lord.
No, let us get the facts first. Up to 50, what is the multiplier?
Up to 50, my lord, 13.
13. And from above 50,
Above 50, my lord. No, above 51, not 50, my. Above 51, your lordship kindly see,
let us see the schedule.
my lord.
Motor
Economy.
vehicle
Excellent. Tell him,
motor
tell
vehicle
him.
sector.
No, no, perat must keep. Copy here too.
That was the level.
Okay. Ahora sí, ahora sí. Ahora sí. Pues sí, pero no. So multiply 14 will be applicable to 51 to 55 years, man. I am in between 50 to 51, man. So in that case, Tosticolas is given.
For 50 years. This is Madam, I think he has a point.
No, that is also valid.
Yeah, I think he has a point.
That's fine. Lordship.
No, no, because why we are saying that on completion of 50, on completion of 50th year, one does not become 51 years. He becomes 50 years. It is only on completion. How do you compute an age? It is on completion. Suppose a baby is born today, he doesn't become 1 year. He will become 1 year after completion of 1 year.
Sasikala.
Has been done.
Done.
Sasikala.
That
That is the case.
Yes.
So I'm putting that,
No, there are
supporting
other there are other analogies which are just the reverse. Suppose a person is entitled to a higher amount, maybe maybe some enhancement in his salary or pension on a particular slabs. When he becomes 80 years, he will become. Then when does a person become 80 years? When he completes 80 years.
That's why
Because the moment
81 birthday.
the 81st
81
birthday,
in 81
he will
birthday,
be completion of 80 years. So, but here the case is just reverse. The Honorable Supreme Court has modified that schedule.
gray area.
Yes.
So that's why Lordship has
Yes, no,
right
but
to
No, that
No,
is
it's-
in another judgment. It is clear.
see, madam, it's not a right. It's only we
is
come to a
beneficial
just
decision.
finding by taking your assistance. But what is the best possible interpretation, and also taking into consideration the objective of the act. And it's not an interpretation which is unreasonable. It's rather we think that it will be the reasonable interpretation, because it has said that from 46 to 50 years, they are reduced by 2 units for every 5 years. He is 50 years, 1 month or so, 1 month, but he has not 51 years. The moment he completes 51 years, then he will come to the other slab.
that part. They,
Okay.
those 12 months.
Okay.
But then what's on the other side is judgment, the court has deducted one. Let us look at the- So that because it's set up to the-
Okay.
So
No,
they might be getting some. So
No,
out
no,
of some-
we'll balance everything. We'll also hear you, whatever is your say, whatever is Mr. Rai's contention. Mr. Mahanta? Yes.
That another judgment, my lord.
No, let us first note some basic facts.
My lord. So that is my first contention.
No, first let us, we have not noted anything. First let us note something. Your appeal is for enhancement.
Yes, my lord.
Which appeal number?
MSc appeal number 168, 2020.
MSc appeal 168 of 2020 for enhancement. How many appeals are there?
Only one.
And appeal, one,
Two cross objection. And what is your cross objection?
my
32 of 2021, cross objection by insurance. And by owner,
appeal.
this is MACT number 2 to Kamrup. MAC case.
Kamrup.
Okay. 2020.
Where's the range?
37,066, 37,66,378.
My lord.
Okay. This was
Deputy Ranger.
Bhadreswar Mali.
Yes.
Date of accident?
23/11/2013.
23/11/13. Date of accident. Boko. Yes. You were a deputy ranger.
Deputy Ranger.
Okay. Yes, now tell. What is
My
it?
lord. So there are three, my lord, PWs, my lord, one DW. Three PWs, my lord. PW one is the
Pre-claimant witness.
claimant witness. Sorry,
Okay.
claimant witness. Claimant Nilimawala Devi, my lord. Wife is the PW one. One PW.
All the claimants are your who are the son, wife and widow and son's daughters.
Yes.
Daughter,
Wife and my lord Chamchandar.
sons. Okay. Yes.
Uh,
Oh.
Then the claimant witness three is the my lord. Claimant.
Just a minute. Huh? One minute. Okay. We'll continue at
My lord.
2 o'clock. There is an online because there is some administrative work now. It was at 3 or 3:30, but we are now we'll have it now on set. But 2 o'clock there is an online of Arunachal matter. By around 2:15 we should be able to have your matter.
2:15.
Yes.
Okay.
Maximum. Okay. Oh, okay. Oh, interview also, no? There may be some adjustment in time.
My lord.
It depends on the. No. We'll complete this. There is some interview actually. It depends when it ends. It was at 3:30, but because of some administrative inconvenience. We're fixing it now. Okay.
Develop.
Network continue to download.
Yes, who's appearing? Mr. Kato, you'll be appearing?
Yes, my lord.
Yes.
I am appearing in review petition, my lord. My lord, my review application is for, my lord, basically review of the order passed by your lordship on 30th January 2024, my lord, wherein direction was given for the, my lord, the payment of the, my lord, the compensation amount
Which,
to
which
the tune
page?
of, my lord,
Which page?
page number, it starts from page number 40, my lord, annexure 4,
40.
my lord. And relevant page is, my lord, may I take your lordships to page number 49, operative
49.
portion, my lord, operative portion. Para 16, my lord. Operative portion is at page number 49, para 16,
Just a minute, please.
my lord.
Paragraph? Paragraph?
My lord, para 16, paragraph 16, my lord.
16.
My
This is
lord,
Judgment and order dated.
page number 49. In view of the above, it is directed that the assessed amount for the standing crops and the properties and the row ROW is communicated by letter number so and so amounting to RS 14 crore 96 lakhs 98,469. Only be released to the petitioners expeditiously, and in any case within a period of 2 months from the date of receipt of a certified copy of this order.
Right, right.
Means the madam.
Now, what is the
Thereafter,
review
my lord,
you are seeking? What is the review you are
my lord, the
seeking?
review is, my lord, the after, my lord, this, my lord, we are seeking for the review of this, my lord, particular, my lord, the amount, my lord.
Yes.
My lord, what happened in
What
after,
are the grounds? What review?
my lord, after the, my lord, receipt of the, my lord, after when we initiated for the payment of the, my lord, amount, then, my lord, there was a documents wherein, my lord, the works, that portion of land has been foreclosed, my lord. Annexure 5, page number 51, my lord. Inadvertently, this documents was not brought to the notice of this honorable court
Annexure 5,
at the time
page
of
51.
correct, my lord. Page number 51, annexure 5, my lord. Type copy is annexure, page number 52, my lord. Original is not legible, my lord. Type copy is page number 52. My lord, this was issued on 27 March 2023, by which, my lord, that by this letter, my lord, the portion of work has been foreclosed by the, my lord, the ministry, my lord, by the higher authority, my lord. May I read, my lord? My lord, the third paragraph, a proposed following is requested. A, constructions on the stage between the kilometers 143 to kilometers 165 to be foreclosed, my lord. That has been closed, and no longer, my lord, this portion of land is required, my lord, and for which, my lord, the compensation is required to be deducted and reduced. And exact, my lord, I have categorically mentioned the exact portion of land which we have taken and the require by the requiring agency is, my lord, only my lord, again, my lord, may I take your lordships to the specific paragraph by which, my lord, we have categorically mentioned page number, my lord, 28, paragraph 9, my lord. The applicant respectfully submits that the out of the total length of the 15 kilometers starts from kilometers, my lord, 143 to kilometers 153, 58, I'm sorry, my lord. The review applicant have constructed total length of 9.205 kilometers only, my lord, which starts from kilometers 143 to kilometers 158, and the remaining length 5.79 kilometers only, which starts from the kilometers 143 to 148, has been foreclosed by the Ministry of Defense, Government of India. As such, the road will no longer form part of the approved Arunachal Frontier highway alignment, and the said factual position has not been brought to the knowledge of this honorable court inadvertently. And this was the our basic area. The states
No,
of lane.
what meaning are you seeking to convey by paragraph 9? See, out of a total length of 15 kilometers,
Correct,
starting
madam.
from 143 to 158, 15, okay.
Yes, madam.
Review
Yes,
applicant
madam.
have constructed total length
Ji.
of 9.205 kilometer, which starts from 143.795 to 158, okay. Remaining
Correct,
7
madam.
only, and the remaining length of the only which starts from 142 to 148 has
Yes,
been
madam.
foreclosed.
This is not required, and this has not been constructed, and this is no longer form part of the national highways, madam. For which the
No,
amount and the
you have
figure.
said, you have stated that you have already constructed 9 kilometers from 143 to 158.
My lord.
Then how can you say that
And there is a
143 to
remaining.
148 has been foreclosed?
My lord, this has been just constructed from the reverse side, my lord. My lord, altogether, the construction activities which has been taken by the user agency is only 9.200 kilometers only, my lord, for which we are
Mr.
ready to
Katu,
pay
we are
the
not on the,
compensation
we are not
amount.
on the distance. We are on the location. We are not on the
Location is,
distance.
my lord, then the same.
Location, you say that
My
you have foreclosed the kilometer 143 to 165 in your letter. In your pleadings, you said that you have foreclosed 143 to 148.795. And in the same
Correct, my
pleadings,
lord.
you say that you have completed from 143 to 158. How does it make any sense?
My lord, it is from the next the ending side, the construction is started, my lord. So therefore, my lord, the
No,
sum and substance, my lord, the construction
will not go
activities.
by what meaning you are seeking to assign. We'll go what meaning generally appears from your pleadings. See, there is a total kilometer from, see, 143 to 158.
158
That is the 15
kilometers.
kilometer range, okay? 15
My
kilometers.
lord.
Now you say that
Out of which
from 143.795 to 158, you have completed. That comes to 9.205 km.
yes,
Now,
ma'am.
how does the foreclosure be possible from 143 to 148? That is under what has been constructed already.
No, my lord, we have not taken any construction activities. Neither it has been taken, my lord, the position by the user agency. It is, my lord, still
Now,
in.
which you have admitted in paragraph 9 that you had constructed 9.205 kilometer, correct?
In total, my lord, out
In
of 50
total, yes,
kilometers.
9025 you have stated from 143.795 to 158 kilometers.
Correct, my
You have
lord.
also stated that. And rest
Yes.
5.795, you have not, it has been
Yes, madam.
foreclosed. Now this foreclosure
Yes, madam.
part, you say it is within the area which has already been constructed. Construction means acquisition of land. You cannot construct without acquiring land.
Department, my lord.
Who will come to you, Mr. Abba?
My lord, therefore, my lord, this is my lord, the instructions which I have received from the department.
And
has
this
been
letter is of 27/3/2023. Now this
True, my lord.
this case was disposed of after considering your pleadings. Now to invoke
Correct,
the review jurisdiction, you have to make out a case that despite
Madam.
your due diligence, you are not aware about something. Now this is a letter of your own department. After
Correct.
pronouncement of the judgment, this letter emerges. Where is the aspect of due diligence? And this was the
My
dispute.
lord,
exactly which was decided after 1 year of his filing.
My lord, admittedly, inadvertently, my lord, this document has not been brought to the notice of this honorable
No,
court at the time of filing.
can inadvertence be one of the grounds for invoking review powers? That
My
is
lord.
one part, number one. Number two, this letter, as per your version, is directly connected with the dispute. Dispute was pending consideration for a year, wherein you had filed your pleadings. And even if you ignore all this aspect, overlook all this aspect, even your explanation is not covering your case. Your explanation says that this is the part where your constructions have been done.
My lord.
Now, if you have made the constructions, where is the question of foreclosing?
My lord, my lord, even then also, my lord, the construction was not taken fully, my lord. During the course of undertaking the construction activities, subsequently this development took place, my lord, by foreclosing some portion of lane, my lord, portion of stage,
Where is
portion
it
of
stated?
road.
Where is it stated in your review application? You have not stated.
My lord, when we initiated for the, my lord, compliance of the order passed by your lordship, then we came to disclose this particular, my lord, document, my lord. Therefore, my lord, we prepared this review application, my lord.
Mr. Kato, the connected pleadings,
My lord.
pleadings in support of the document which you're trying to rely upon, is the pleadings are at paragraph 9. We have
Paragraph 8
read,
also, my lord.
we have reread.
Yes,
9
my lord.
and 9, you have nowhere
8 and
expressed.
9, my lord. 8 and 9, my lord.
9 is 8 is only the amount part. 9 is the factual part.
My lord. My lord, may I read, my lord, paragraph 8, my lord.
8, okay. Let us
Well,
read it.
my lord.
Yes,
While
please
examining
read.
the appropriate, my lord, I am reading
Yes,
paragraph
please,
8,
please.
page number 27, my lord. While examining the aforesaid matters on receipt of the certified copy of the judgment and order dated 30th January 2024, passed in the aforesaid writ petition, has come to know that some portions of lane from kilometers 148 point some so and so to kilometers 143, total length of 5.795 kilometer has been foreclosed as per the directions of the Directorate General of Military Operations by letter number 27 March 2023. As such, the from kilometers 53 to kilometer 48 point so and so total length for 9.205 kilometer has only been executed out of the entire stretch of length from kilometers 143 to kilometer 153. The remaining length measuring total length of 5.795 kilometer is no longer required by the user agency for construction of road. However, this factor has not been brought to the notice of this honorable court inadvertently by the department and the review applicant at the time of filing the affidavit and the hearing of the matter. Therefore, the compensation in respect of the stretch of the length measuring 5.795 kilometers, which have already been foreclosed by the Ministry of Defense, cannot be paid at this stage, and assessment in respect of the stretch of the 5.795 kilometer has not been damaged, and same will be no longer required by the the review applicant user agency on being foreclosed by the Ministry of Defense. Therefore, the review in respect of the assessment amount to the tune of the 14 crore 96 lakhs 98,463 only is required to be reassessed, and the reassessment against the land actually taken and executed by the review applicant may be allowed to pay on the said subsequent development, madam. This is the my submission only, madam. This extent only, madam. My prayer is, madam, very limited, and for review of the this particular stage of land.
So according to you, the amount will be reduced.
Madam.
Reduced by how many, what amount?
My lord, that will be appropriately counted by the assessed by the my lord, the district administration, my lord. Admittedly, my lord, it is mistakes on the part of the department.
Your paragraph
The
9
motion-
readings are misleading. 8, I think 8 is a proper, better
My
explanation.
lord, my lord, my lord. I'm sorry, my lord. Paragraph 8 is my lord, correct,
8 perhaps would make some meaning.
my lord. My lord, this is the limited barrier, my lord. Once it assessed and the calculation is done, my lord, automatically, my lord, the total and the compensation liable to be paid by the department will be ascertained, my lord. We are ready to pay, my lord, for to that extent, my lord.
I think there's a printing error in the 4th line of paragraph 9. That is creating the difficulty. And tomorrow again, you'll be seeking review. Come to paragraph 9, 4th line,
Fourth line, my lord.
paragraph 9.
And remaining length 5.795 kilometers.
Fourth line, which starts from 143. It's not 143, it should be 148.
I'm sorry, my lord, that may be clerical mistakes, my lord.
It should be 148.795 to 158. Because from 143 to 148.795, you said you had foreclosed, and from 148.795 to 158, you have done. This, it should not be 143, it should be 148.795, fourth line. Fourth line from the top, paragraph 9.
My lord.
But these are matters which were within your knowledge. How does this court invoke review jurisdiction, review powers? It is not because of, even after due diligence, it was not discovered. The discovery is after. Yes, Mr. Abha.
Lordship has rightly observed how there can be review if given the facts and circumstances of this matter.
You file your
And,
you file your objection.
Learned friend from other side, my lord, has submitted wrongly, my lord. Factually, my friend is not correct, my lord. This is repetition, my lord, was for compensation of Zerat, my lord. An assessment had already been done, my lord. And the assessment relates to 2017, my lord. And it started from 2015. And the letter which has been referred to, my lord, here, my lord, is of 2023, my lord.
Yes.
And it's nowhere connected with the land compensation, my lord. It is the compensation for Zerat, which had, I mean, the standing crop and whatever property was there on the land already damaged, my lord. It is a fait accompli, my lord. It cannot be undone right at this moment.
Is it for Jirat?
Zerat, my lord.
Let us see the, have a look
Land
at the,
compensation had already been given.
Page number, my lord, 49, my lord.
49.
My lord.
Even in paragraph 3, my lord,
Oh,
of the review
it is
petition.
for Jirat. For Jirat, whether you have foreclosed or not, your damage has
That is-
already been done.
My lord, we have categorically mentioned, my lord, we have not damaged anything, my lord.
No, see, in paragraph 14, at page 149, of page 49, this court has come to a categorical finding. This court, therefore, the present claim is not in connection with the land in question, but for the Jirat which has been specified.
My lord.
Admitted fact, my lord, in paragraph 3 of the review petition. Paragraph 3 of
And
the,
whether you have foreclosed or not, whether you have made the construction or not,
how it is
that
connected, my
will
lord.
not be relevant. If you have damaged
my
the
lord-
property and ultimately have not acquired the land, you may not be liable to pay acquisition compensation. But the Jirat compensation that you have to pay.
Otherwise,
My
also,
lord,
my lord, on the question of law, my lord.
My lord, our pleaded case is we have not touched, we have not damaged anything, madam.
No, that is not the ground of review.
It was not pleaded in the writ petition.
That is not the ground of review. Ground of review is foreclosing a particular distance regarding construction. But the assessment was done in the year 2017 itself.
Well,
Your decision to foreclose came in 2023.
correct, madam.
And on the question of law, my lord, the power of review would be available only to correct error apparent on the face of the record, which can be identified without any elaborate argument.
Mr. Kato may not be a fit case. Yes. Look.
There are several landmark judgments on this.
Yes, any decision you'd
My
like
lord.
to cite?
I would rely on my lord.
उस केस का नाम क्या है? मधुसूदन क्या है? रिव्यू का मधुसूदन क्या है? क्या मधुसूदन क्या नाम है? अरे, हमें सब तो क्या मधुसूदन? हाँ? First name S ना? Versus Nan.
2020 SC 813. Ram Sahu, Death Pro LRS versus Vinod Kumar Rawat and others. 2020 SCC online SC 896. Paragraph 10, 11, 11, 11.1 and 14. The other one is, my lord,
Just a minute, please. Paragraph?
paragraph 10, 11, 11.1 and 14.
Yes.
The other relevant judgment, my lord, which I did have 1979 for SSC 389.
Manipur judgment.
My lord, Aribam Tuleshwar Sharma
Yes,
versus.
Manipur judgment.
Yes, my lord. Paragraph 3.
Nineteen 79. Aribam. Paragraph?
Paragraph 3, my lord.
Paragraph 3. Yes.
I prepare a small note, my lord, if lordship permits, like small note.
Note.
My most humble submission is this review petition liable for lack of merits and as well as on the question of
Where is the latest judgment on review?
it is 2024.
Where is the latest? 20 is not latest.
I will supply.
When? After the judgment? Okay, have your seat, please. Heard. Re M. Kato Landit CGC, Arunachal Pradesh, who has appeared online for the applicant. First of also heard Sri S.R. Rabha, Learned Counsel for the opposite parties, writ petitioners. Full stop para by the present application, comma, review has been sought for the judgment and order dated 30/1/2024 of this court in WPC 18 of 2023. Full stop. By the Guwahati High Court rules. By the aforesaid judgment, comma, this court had allowed the writ petition by directing payment of the compensation assessed for the standing crops and properties and ROW as per the communication dated 13/10/2017. Full stop. Para. Sri Kato, the learned CGC, has submitted that the claim was in respect of construction of the Hunli Matengliang Huangliang Defense Road है यहाँ से देख लीजिए for the portion KM 143 to KM 158 in the Anja ANJW district in the state of Arunachal Pradesh. Full stop. Para. No. By para nahi, see. The Learned Council has referred to a communication dated 27/3/2023, which has been annexed to the review petition as Annexure 5. Mr. Kato, Annexure 5.
My lord.
Annexure 5.
Yes, my lord.
And has contended that the construction on the stretch between kilometer 143 2 km 165 was to be foreclosed. Full stop. The learned CGC has referred to the connected pleadings in paragraph 8 and 9 of the review petition. Full stop. The pleadings, however, in this the learned CGC has referred to the pleadings in connection with the aforesaid communication. Full stop. Para. It is submitted that the aforesaid communication could be discovered only at the time when steps were taken for implementation of the judgment, and therefore the application has been filed for review. Full stop. Para. The learned CGC has submitted that when a portion of the concerned highway was foreclosed and not utilized, the applicant cannot be burdened with payment of compensation. Full stop. Para. Per contra, Sri S. R. Rabha, learned counsel for the opposite parties, writ petitioners, has submitted that the entire projection in the review petition is misconceived. Full stop. It is submitted that the amount in question was only for the Jirat and not for acquisition of the land. Full stop. It is submitted that the assessment was done in the year 2017, and thereafter the amount was and thereafter the valuation was done by the administration with full knowledge of the requiring department. Full stop. The writ petition was instituted for non-payment of the estimated amount for the Jirat. Full stop. It is submitted that the communication dated 27/3/2023 was very much existing at the time of adjudication of the writ petition, and therefore such communication cannot be the ground of filing a review. Full stop. He otherwise submits that the contents of the communication is not relevant for the purpose of adjudication of this case, as the same has nothing to do with the compensation for the Jirat. Full stop. Para. In support of his submission, the learned counsel for the opposite parties respondents has relied upon the decision of the Honorable Supreme Court in the case of Ram Sahu reported in 2020. Reported in AIR 2020, Supreme Court 813. Full stop. It is submitted that the power of review would be available only to correct an error apparent on the face of the record, for which no elaborate argument is required, and a review cannot be an appeal in disguise. Full stop. The learned counsel has also referred to the case of Aribam Thulesar Singh Sharma, reported in so and so, wherein it has been laid down that while a High Court exercising powers under Article 226 cannot be held to be precluded from the plenary jurisdiction, including exercising powers of review, such powers are to be exercised only on exceptional circumstances and not on ground that the decision was erroneous on merits. Full stop. Para. The rival submissions have been duly considered. Para. The judgment dated
30 January, madam.
30
January.
2024, which is the subject matter of review, is admittedly on the aspect of Ziraat compensation and not for acquisition compensation of the land. Full stop. In fact, in paragraph 14 of the said judgment, the aforesaid aspect was expressly mentioned. Full stop. Para, for ready reference, comma, paragraph 14 of the judgment is extracted here in below. Full stop. Para. The ground for review is based upon a communication dated 27/3/2023. Apart from the fact that the said communication was initiated by the office of the present applicants who were the respondents, comma, the same was an existing communication, and on the own admission of the applicants is intrinsically connected with the subject matter involved with the writ petition. Full stop. Therefore, comma, the said letter cannot be held to be a discovery of a document which, even after exercise of due diligence, was not within the knowledge of the applicant. Full stop. Para, that apart, comma, the relevant pleadings in the review application are found in paragraph 8 and 9, which are connected to the aforesaid communication dated 27/3/2023, full stop. While as per the communication, the construction of the stretch from KM 143 to KM 165 was to be foreclosed, comma, the pleadings are totally different, as per which out of the total length of 15 kilometers from KM 143 to KM 158, comma, only the constructions were done of a stretch of 9.205 kilometers from KM 143.795 to KM 158.000. And the remaining portion, which was foreclosed, is of 5.795 kilometer, starting from KM 143.000 to 148.795. Full stop. Para. There is an apparent inconsistencies with the stand taken by the applicant vis-a-vis the communication relied upon and the pleadings. Full stop. Be that as it may, comma, as noted above, the controversy is not with regard to acquisition compensation, but of GIRAT compensation. Full stop. This court has already recorded in the judgment under review, judgment in respect of which this application has been filed, that the assessment was made in the year 2017 when the preparations were made for construction, causing damage to the standing crops and properties, and accordingly the GIRAT valuation was made. Full stop. The said valuation cannot be connected to the decision taken in the year 2023, as would appear from the communication relied upon, which relates only to foreclosure of a particular stretch of the highway concerned. Full stop. Para. This court has also noted that Chapter 10 of the Guwahati High Court rules which is on the aspect of filing applications for review, prescribes for framing concise grounds of review. Full stop. In the instant application, no such grounds have been framed. Full stop. Para. However, comma, even without going to the technical aspect of the matter, comma, this court is of the considered opinion that the grounds which have been already canvassed in support of the review application by taking support of the communication dated 27/3/2023, read with the relevant pleadings in paragraphs 8 and 9 of the application are not at all relevant and therefore cannot be grounds for invoking the powers of review by this court qua the judgment and order dated 31/2024 passed in WPC 18 of 2023. Full stop. The review application is accordingly dismissed. Yes.
My lord.
Clear, brother.
Development.
Before my management start, may I take indulgence of a lordship?
What intelligence?
Lordship,
You're inviting for something?
Lordship, item 18 and 19 as lordship, take the matter after.
These indulgence, we thought you said we'll have other indulgence. Vacations are approaching.
No, lordship, I'm not, lordship, take me kindly.
Date for what? Invitation?
No. I'll be happy.
We are available every day.
So that will say, invite separately. But lordship, lordship.
Which item?
And 19 and 20.
Who's for the other side?
After Goswami was there, he was also not present before the lordship when the matter was called. Supplement list.
19 and 20. This was called for.
Yes, called for lordship, but no, neither the appellant nor the, I was also.
Oh, you both were absent.
Lordship, may I pray that it date may be fixed after vacation.
It's already signed.
Because lordship.
It's already online.
No, that is,
You have to file a review.
no, I'm not. Just saying that.
No, we have signed it. You should have made first you were not present. Then you did not come to the court thereafter also. You should have at least made a mention before we had risen. Neither Mr. Goswami nor you were there.
No, nobody was there.
And it was not called out of turn.
No, yes, sir. That is, no, I'm not blaming anybody, Lord. Because it was my fault. I was on like.
Today there was no rush also.
Yes, actually, I was
There was no rush.
on lakes in October 13.
That is, there was no rush, no traffic.
No, I'm not taking that. I was present in the court. I was arguing in court number 13.
Your friend was also not there.
Yes, Lord. Nobody was there. That is,
We have signed. Which date are you seeking?
Lord,
No, but if it's signed, we cannot help. If
Then
it's
we'll
not signed, then we might.
I'll make a mention.
Huh?
I'll make a mention.
No, which date are you seeking?
Lord,
Which date are you
Lord,
seeking?
15
Huh?
or reopening date.
Date to the name. After vacation. Fine, we will take it. Okay, just give a reminder. Huh? Item number
Item
1890.
19 and 20, 19, 20.
If it's not signed, we'll try to give
Lord,
it. Okay.
much.
But my enhancement only purely on three, just three round, my lord.
Just a minute, please. Okay. Itu about to tweet, huh? Someone. Itu earning. Itu na file to. Itu. Death of accident, there's the article, deputy ranger, 3 claimants. Okay, you were on the aspect, there were 3 claimant witness.
Yes, three
The-
claimant. witness.
Thereafter,
One official witness, my lord, one, my lord, by the defense side, my lord, that is one.
1 defense witness, 1 defendant witness,
TW one,
1 OP.
so my lord, my purely on ground that, first is deduction,
First ground,
deduction.
deduction is
That is multiplier, sorry. my lord.
Multiplier.
Multiplier, my lord, according to my lord, that's Sarla and my lord, then there is
Uh,
another judgment, two judgment,
Multiplier should be
13, my lord,
13,
instead of 11.
11 taken.
My lord, 11 taken. That is my first one. Second point, my lord, for enhancement. Normally, my lord, what are the salary taken into my lord? It is a deductible, my lord. After deducting, my lord, after deducting TDS, my lord, it is been placed before the court, my lord. That is normally situation, my lord. That is already taken by the another judgment also, my lord. But here, my lord, again it was deducted, my lord. 10% deducted
From
from my last pay certificate.
10% as tax, TDS,
TDS by the court.
double deduction.
That's why, my lord. And another, that is second and third is that, my lord, 1% interest. That is I have never seen, my interest is 1%. You will kindly see para 31 of the judgment. No interest was paid even. And last, my you will kindly see para my lord 31 of the judgment. Page 13, 1-3.
One, three.
1-3.
Yes.
Accordingly, the opposite party number 3, the National Insurance Company Limited is directed to make payment of rupees 37,66,378 within a period of 3 months from today.
Interest has been given.
The compensation amount shall be carried interest at the bank rate of fixed deposit from at the bank deposit fixed date of deposit from the 26/3/2019 recorded 27/22. Yes. Yes, my lord. 1% is additional. মানে ব্যাংকৰ যিটো rate, bank fixed rate. That bank fixed deposit rate is, my lord, vary to vary, bank to bank, it is vary, my lord. Shall carry a interest at the bank rate for fixed deposit from.
That is okay.
So, my lord,
You will get, that is the maximum you will get, fixed deposit rate.
my lord, but it will vary to bank to bank. There are no fixed, first fixed, my lord.
No, it can be 9%, it can be 6%.
My lord, bank to bank vary, my lord.
Yes.
All right, my lord, that is my submission.
According to you, how much should be the rate of interest?
They normally, my lord, 9% awarded, my lord.
Huh?
I have seen the some case, no, it's bank to bank vary, my lord. In some
Now,
cases,
how much percent are you expecting?
my
As per
lord,
your expectation, what should be the rate of interest?
rate of interest normally 9%, my lord.
9%. Yes.
My lord. Right?
That we can consider, we'll say, here the other side, 9%.
My lord. That's my
We have seen 6% also, 9. What is the fixed deposit rate?
fixed deposit rate, my lord, for nowadays, my lord, for senior citizen is different. For senior citizen it is up to 9.9 in some bank, my lord. After 60 years,
9.9.
9.9.
Which bank?
Northeast Bank, my lord. I came across that was sent to
Northeast
me.
is the proper bank or some,
And it's a bank, my lord, proper bank.
not, tomorrow it's not going to disappear.
Probably, my lord, is a RBI guy. RBI.
We have seen many RBI sponsored bank disappearing.
My lord.
If it is 9.9, I'll enhance my age and get retirement tomorrow.
But 9 plus, my lord. I'm not exactly 9.9, 9 plus. In
But
most of the
9
bank, it is 6%, 6 to 7.
But 9% we have seen 9%, yes,
But-
9%.
My lord, most of the bank, my lord, 6 point. 6 to 7 fixed deposit rate.
Okay. Okay, then anything else?
That's all, my lord.
Multiplier.
Okay.
Then interest rate should be,
And fixed, my lord.
and the, your TDS
Tax deduct.
was done twice. The
Already, my lord,
salary which you had projected was already after deduction,
after deduction.
and therefore there was no occasion to deduct further
Again, my
10%. Okay. Yes,
There is a my.
Any decision?
Yes, my lord. Regarding my lord, that multiplier, my lord, there are two decisions I am going to place, my lord.
No, Sarla Burma has, but what about the decision of this nature? Where you have just crossed 50, you are not reached 51.
Or that in Sarla itself is, my lord, reflected, and my lord, another judgment, my lord, I will give him, my lord.
Yes, yes.
Sasikala. Sasikala judgment, my lord.
Shashikala,
Yes, my lord, that is 2015 9 SCC,
2000?
2019, 2015 9
First,
SCC.
let us record Sarla Burma. 2009, 2009,
Sarla edition.
6 SCC, 121 Sarla Burma. Sarla Burma, which
There are
paragraph
42
regarding
multiplier.
multiplier? Okay. Then the other one,
Other one, my lord, is 2015 9 SCC,
2015, 9 SCC,
150.
150.
Para 16, my lord. 16. That's fine.
Sasikala. Okay.
Para 16 clearly. And regarding, my lord, test deduction, my lord, is a normal procedure, my lord. If it is objected, my lord, it is the duty of the objector to prove it, my lord. That is the judgment, my lord. I will place before your lordship. That is 2013 7 STC.
Page,
476.
where?
Para, my lord, 23, 24, and 25. I will give a judgment, my lord. I don't know.
23,
clear.
24, and 25.
25. That is the judgment.
Name.
Name, my lord, that Bimal Kanwar and other buses, Isu Dam. Isu Dan and others.
Paragraph 24.
23, 24, and 25.
Okay,
That's fine. And regarding my lord, 9%, I got take this one judgment.
please.
Fine. Two 2022 5 SCC 107. Para 13, my lord.
2022 5 SCC
That is the judgment,
107 para 32.
my lord. Last but one para.
Paragraph
Last but one, 32 port.
13. No, this is here, 9% has been granted, but is there any case on discussing what is the
No.
appropriate rate of interest? This is a case where normally,
Normally, my lord. So basically, that is my case. And very interesting, my lord. Till today, he is not getting anything. Till today, my lord. In fact, my lord, I filed an application for early hearing because my lord, claimant that was marriage was,
No, is there any stay order?
there is no stay order, my lord, when case is pending and there is a cross objection filed, my lord.
No, in the cross-examination, is there any stay? No stay.
No,
But why didn't you go for execution?
normally when case is pending before the High Court,
No, first you had filed for enhancement.
my lord.
You're
So
not aggrieved,
amendments,
you're not aggrieved by the award, you're only
yes,
saying,
absolutely.
even if your case appeal is dismissed, that amount is still intact.
Still intact, my lord.
You could have gone for execution without prejudice to your rights. No, before even hearing the other sides, there is one problem which would be a very practical problem for you. The
Will
cross
do.
appeal is both by the owner and the insurance company.
My lord,
Insurance company is aggrieved by the observation that pay and recover.
pain,
According to them, they are rightly been held not to be liable, but for the, at that time, the tribunal decided that you pay, then you recover from the owner. And there are case laws that kind of observation is perhaps not proper. Okay, later case laws. Initially, there were case laws where this was done. To that extent, it had been that separate decree is not required. You can straight away execute for recovery. But that has been slightly changed. So the recourse which should be left for you while executing is against the owner.
my,
You know the difficulty which you'll be
Right.
facing. So that is the practical difficulty which ultimately will come.
my lord, probably that is the reason, my lord. Nobody is going to pay, my lord. Today.
That is exactly. And tomorrow you go for execution.
Against whom
If-
I will go.
No, you'll go against the owner. He doesn't have an amount. He'll go to civil imprisonment. You'll get
I will
nothing.
not get in.
Mr. Rai, what are you saying? What do you do?
Yes, well, I have already retired.
As
As my lord, school, my lord, staff,
school staff?
that clerical. I have already retired. My first commission, yes,
Madam Mazumdar, without going into the niceties of law, how do you resolve this kind of, ultimately death has been caused. You are maybe absolutely right in contending that he did not have a valid driving license. Assuming you are correct, there is violation of the policy conditions. But practically he'll not be able to pay 37 lakhs.
yes, I am not careful.
No. Madam, those things we know. But how practical will be, we do not even know what property he has. That is why we are asking, what do you do? He says he's retired from a school job. Normally, well, let us assume he may not have that much of resource to
70 years.
pull to make an amount, to meet an amount of 37 lakhs. I'm not discussing in the context of this case. This case will go by law, but how do you resolve actually?
That some cases get the company pay, you know. That's
Yes.
the top one. They will try to say that the judgment is not carried. The court is saying that we will be going to be punished by article. There is no number, nothing. For all these numbers. But and also second part is that we have totally balanced the reduction of the compensation. First, they have the relatively cheap food working as a business. And then but this was never one salary is
Hmm.
and another 7.
Is there any difference in the two certificates?
And there is a difference. One is That.
Now, which is the salary certificate of a later date?
Seven. No, 6 was for a month and 7 was in 10. But no service was right now. Because you office part is
No, salary slip is also okay.
but then also not as per 6 5 the month by but I cannot I take I think but they don't want
Now, how much has the tribunal taken?
as per and what's the attention that the next was deducted.
This 34,114 was considered after deducting 10% of the TDS.
But this now that part I'm coming, that period. Consider that yeah, but there is no mention of reduction of tax. Payments are saying that that salary was after reduction of tax. But there is no mention of that. Satavarma, one side we cannot accept that. Satavarma accept tax. So Satavarma accepts that the comes the accident after deducting the tax.
No, no, they are not going against the principal's leaders. They say that the deduction was already made.
So that the salary
So
that
you want
was
to
added-
you want to contend that there is no materials on record by which they could have contended that 10% was already deducted. What about their witnesses? What was the evidence on the part of deduction of TDS? From Mr. Mahanta, from where are you making this submission?
My lord.
That the
Normally,
salary which you had projected was already after deduction of TDS.
normally, my lord, it is always, my lord, taken into my lord after deducting, so those who are salaried, those who are deductible, my
No,
lord.
no, we cannot be on assumption.
No, my lord, that is that's why I'm submitting the judgment. In judgment, my lord, that was said, my lord, normally it will be taken into my lord that after deducting, but the statutory duty of para 23, 24, it is clearly mentioned, my lord.
Vimal.
Vimal Kanwar.
But it is not true. That will become rate from. That there is no mention regarding that deduction, etc. from the salary. I have not got in chief that on that. I just see very small. Receiving
No,
from
no.
that I have come. Right,
This is the official
Oh.
of the forest department.
for it. That.
We can post part.
Date of birth was March 20. For the month. Then you say, okay, that is I was not what the book. That's that part. After
Okay, we'll come to, yes, Mr.
My assumption in from the tribunal, I never received any, my lord, notice because order dated 8/3/18, 2018. Tribunal has clearly stated, my lord, presumed to have been served.
Which order?
Order dated 8/3/2018. 8/3/2018. Next, my lord, your lordship, exhibit 1.
Now, why didn't you file an application for setting aside ex parte?
But actually, I was not aware about the, my lord, here. When I checked the notice there.
That is
about
it.
then
Why
I
didn't you
checked-
apply for setting aside ex parte? Did you apply? No.
No, I was not aware about that. So after
No,
notice,
after being aware, what precluded you
Yeah.
from filing vacating ex parte?
Yeah, my lord.
You have not
Yeah.
done. Okay, doesn't matter. You can still file appeal, okay? Okay.
Yes, exhibit 1 and 4. This is, my lord, exhibit form 54. Driving license number has been given here specifically.
Exhibit
Exhibit 1,
is what?
form 54.
Yes, form 54.
Yes, driving license has been given, and on that basis, my lord,
Let me see.
page 45. Point number 7.
Yes.
number.
Yes.
Then exhibit 4, page 50.
Serial number 7.
Yes,
DL.
DL.
Your name is Rajan Chandra Brahma.
Yes. Rajan Chandra Pompo.
Yes.
Then exhibit 4, your lordship, page 50. This is from QOP. Same number has been given. DL number. Point number 3.
What is this?
This is driving license number.
No, what is this document?
DTO office, my lord, report. MBI report. MBI report.
Yes.
Point number 3. And it has driving license also given and valid up to 21/10/2014.
Okay.
Instance number is also given, which is also valid up to 15/3/2014. Instance number. These two documents clearly stated this is the number. Now, your lordship, para 27 of the judgment, 26 of the judgment. Para 26.
Internal page?
Internal base, my lord, 6.
Yes.
26 para. The defined, my lord, separate driving license number has been given. And that has been considered. And from this license and was not my lord, valid number, and that was for the period during the date of the occurrence of the incident. 27, 26 and 27 is, my lord, very important
OP
in
number
this
one.
regard.
Your OP number one. Your OP number one.
Yes. OP
In the-
number. One. Yeah. In their OP number one is.
Now, what is the meaning
Yeah.
of this? Please read 26.
OP number one has adduced evidence, but I have never my lord, appeared there. Has appeared evidence and one witness is, namely Ashish Bhattacharjee, investigator of the insurance company. And
No,
Just-
it has not said that you had yourself appeared as a witness. You had adduced evidence through one
no,
witness.
this is not my investigator, my lord. This is insurance company actually.
DW1.
I-
Why is it DW1?
Yes, but I never
By the
appeared.
insurance company.
Yeah.
Okay.
Insurance company, investigator of the insurance company. And he has, number has been wrongly written here. And he has produced this, my lord, driving license. Now, Learned Tribunal, without basing on Exhibit 1 and Exhibit 4, based on this, my lord, driving license and liability has given on.
Where is the exhibit B? What is exhibit B?
Exhibit, my lord, that is another report, Exhibit B. Mhm. Of the instance. Driving license. Exhibit B is the driving license that has been given.
Exhibit B. Let's say exhibit B.
Exhibit C has been called on later on.
Just a minute, please. Where do you get this number? Driving license for 4160
I do not know
99 KW.
where from investigator has got this.
No, he has not said.
Yes, witness DW1.
Yes, we have the we have what he has said. We have the evidence of DW1.
DW1.
When was the accident?
31, 23, 11, 13.
23. 2311.
11, 2013. At about 4:55 PM. November, in the month of November, evening 44:55.
Mr. Roy, you know what has happened, what has happened.
My license, my driving license is valid on that day and instance.
Which driving license was valid?
This is my driving license which has been.
What is your driving license?
This-
Which
yes.
one?
This is the annexure A of my cross, object
Number?
number.
Driving license number?
Yep.
But 1, 8, 7,
This is valid from when?
7,009, 21, 10, 2014,
611
7,009,
to
21, 10, 2014.
where do you get annexure, exhibit?
It's a- it's PI
No, this is not exhibited. Mr. Roy, it has not been exhibited.
Exhibit 4 has been exhibited.
Exhibit
Same
4,
number.
4 by,
TTO office report, my lord, NPI
Yes.
report.
yes, exhibit 4, yes, we'll come to that.
NPI report has clearly stated same thing.
No, DTO, the accident information report has only given the driving license number,
Yes, but TTO report,
DTO report,
exhibit 4,
exhibit 4.
is 50. Point number 3.
Driving license valid up to
21.
21/10/2014.
This type can show here.
Hmm. 21/14. And which is your cross objection? 42.
40.
Annexure?
Yeah.
Annexure?
Annexure A,
Age?
case 10.
What is the validity?
That is the, my lord, date of the validity 21/10/2014.
Non-transport.
No, no, same number.
No, there are two validity here.
Well, that is
Valid till non-transport is separate date, transport is separate date.
non-transport. This is my lord, all pro, personal vehicle. So this number is valid, my lord, and same has been mentioned in exhibit 4 and exhibit 3 also. The seizure list also makes it clear.
What is the finding of the learned court regarding the license?
Hearing license, my lord, page 26 and 27 has been discussed.
Paragraph.
Paragraph 26 and 27. Another license has been discussed. Paragraph 26 and 27. Yeah, it has been stated OP1, that is wrongly stated.
Yes, 27, madam, there is finding in 27. No, there, see, let us, we have the records before us. We had a cursory glance, but what has emerged is that initially he had in his driving license was indeed number 416999K. That was valid from 1999 to 2/5/2009. No problem with that. And as per your investigator, the present license was valid from 14 to 19. Correct? And non-trespass. And the DA and the accident had occurred in a period when there was no license. That is the projection. Okay, now there are materials on record to show that while his initial license, which had expired in the year 2009, thereafter, from 6/11/2009, he had a non-transport license and he has exhibited that here. No, in the cross-objection. Cross-objection. No, we have also thought about that. There is no application under 41/27. That's a different matter. But the Form 54 and the seizure list, Form 54 records a particular number and also the validity. The second one. The second one.
Later on, in the DTO report, they have accepted that year, and we have accepted that year does not have validity.
Or also there.
Oh, seizure list, there is an overwriting.
Yes, we have asked. We accepted that, it was no time to that's activity of it is total manufacturing. This year, whatever they are saying, whatever we as loss of system, they have not.
What about the exhibit 4 MVI report?
Maybe some better date that there also I find the wrong function. What is the cross mark that so value of 21 and the report does not see the validity of a tier function. That submission cannot be taken up. That MPI report is to be MPI report is not any of these there is a cross mark, the authorized to drive.
No, it's not, it's there, thereafter nothing is there, therefore he has given the cross. Because while describing the vehicles which is authorized, after a particular
then-
thing, he gives a cross so that there is no vehicle can be added. Just
then
like a check, you give it.
Like, but the thing is, did you make that? And that doesn't. The court made the
Mr. Rai,
41.
Mr. Rai, why don't you file an application under 4127? Let them give a chance. See your document which you have annexed for the first time in an appeal on the ground that you have not received.
Yeah.
You could not contest. It may be a fact, but to have that document examined or considered in accordance with law, you have to file an application to allow you to adduce evidence at the appellate stage. We may ourselves
Yes.
have the evidence recorded, we can remand it to the tribunal for this aspect.
I could just. that-
We can record the evidence, we may not remand it for a single purpose.
Yes, sir.
Let him come, he'll
Yes,
say,
that might be-
at least you'll have the opportunity of cross-examination.
So we know that then. that is rather if we fight the case that if it is. So that we can bring in the latest real.
But whatever you are doing, it is for the benefit of the claimants. But any further delay is causing further problem to the claimant.
That's it's not. I mean that.
Why we are doing the exercise that if the liability is shifted to you
Yeah, that other-
after hearing all the parties, then the claimant has a chance to get something. Otherwise, nothing. It will be a paper decree. No, madam, you can rest assured that we are not going to saddle you with something which you are not legally bound. But if there is a scope which who might have appeared, but you have shown the overwriting. Overwriting is there.
Yes, okay. This really this year also. Sir, in fact, in my file, I have another DM of the same person,
It-
with different values.
It
But
can be proved
since
here.
we have not filed it, or we have not, I have not reviewed that. But this person and he's making up this.
I think, my lord, if it is then I shall have the scope to call for the DP office to examine actually what is the number and what is, so that comes. I think one person will be prejudiced for
But
this something.
20 of that here, if I have a I'm not taking it. It's now again the latest season, not what you think. And it comes to instance here, not what you think. That is what the order is. And once you haven't received from 2016, the total ultimately in 2018 that was started for the payment part. And then what? And not once, step for not taken by the payment months. Payment to step, achieve 2016, again 2016. And then.
Mr. Roy, we don't find too much bona fide on your part. This cross objection is pending since 2021. You have not even filed an application under 47 to 21.
Another point, my lord, on 26/7/2016, the claimant was asked to take the step, but that has not been taken by them. And ultimately, court has presumed that copy has been served to me. And on the basis of presumption. and
No, we are on the,
Yeah.
let us assume what you have stated is correct. You have approached this court in the year 2021, we are in 2024. There is no application till now under 4127. You could have at least, because that is the only document which you are relying upon. Your reliance upon the scissor list is doubtful. There are overwritings, there are questions in the cross-examination not being able to be explained properly.
one document is, my lord, DPO office, there was exhibit 4 and exhibit 1. That is, my
Exhibit
lord,
1 does not mention the
yes.
period.
Yes.
Exhibit 1 is not conclusive.
No, not wrong. but
Exhibit 4 is the only document.
only document.
Exhibit 4 is, Madam is saying that MVI cannot be a document to
Yes.
examine the validity of a license. That is only for the purpose, what is
So-
the damage?
If I get the chance, then I can prove it by working.
No,
out.
we are not here to give you any advice. You have not done. We fix another date, will not say anything. If it doesn't file, we'll go ahead with this.
Then I shall file, shall file.
Okay. We wanted to dispose this of old case and people are suffering. And nobody as such is on the quantum except the claimant. But nonetheless, you are on the liability. Who will be liable? He is saying that the insurance will be liable, insurance saying the owner will be liable. Quantum, if at all, the claimant is slightly aggrieved, wants a further enhancement. But that amount is yet to be paid. This is unfortunate. Paucity of time did not permit the matter to be taken up. In its entirety. And taken up. List immediately after the vacation. Will not make it part of you
20th or 21st July.
immediately after. Shall we fix a date?
Yes.
List on, as requested, list on 20?
20th July.
20, not 20 is Friday, Saturday.
Yeah.
We'll have it on 23rd of July.
My lord.
23rd of July. If it comes before this court, very well.
Develop.
হঠাৎ করে দেন, না লাগে ডিপোর্টেড না। Yes. Mr. Doctor, anything urgent?
Lord,
Therefore, the
my,
other side, Mr. Chaudhary.
I had to talk with my learned friend. My lord, the challenge in this appeal is the income of the deceased and so for future prospect, as the lordship is aware, they are not entitled to get any interest. So he has agreed to slash down the income from 15,000 to rupees 14,000 and interest of our future prospect, they are not paid. So
The
these are the-
interest on the, have you worked out the amount?
My lord, I'll work it out and your lordship may keep tomorrow.
You give it tomorrow.
Well.
Report করবা, huh? It is submitted. Huh?
It will be.
It is submitted that there is a general consensus regarding the resolution of the dispute. Sarah, list it tomorrow for consideration.
Obliged.
You can mention the matter also.
My lord.
Tomorrow matters will be more, so you can mention it.
Right.
But both of you
Will be ready with the
calculate and let it be a joint sheet.
Yes,
Okay.
please. Obliged.
Anything?
We are both for item number 11, lordship. The date may be fixed.
He'll give a date. He'll give a date, don't worry. You are also there, Mr. Krishna,
Yeah.
you are also there, same matter.
Yeah, 11, same matter.